apologize. On Friday, I left without even telling you guys what time to come back, and here you're up all on time. Everyone have a good weekend?
Yes.
Good, good. Anything further on behalf of the defense?
Yes, Your Honor. First, logistically, Your Honor, we have a stipulation to read to the ladies on the jury, as well as a playing of an audio tape.
Okay, Mason.
This is stipulation of the parties. State of Ohio versus Andrew Mitchell, 19 CR 1662. Joint exhibit number 7. The parties stipulate as follows. If called to testify, Laura Thomas would testify that on August 23, 2018, she worked for the Columbus Police Department in the dispatch department. She would testify that she collected the 911 call that had arisen out of this incident and provided it to Detective Shepard. If called, she would testify that this is a fair and accurate copy of the 911 call as it occurred on August 23, 2018. The 911 call is marked as a joint exhibit number 7. Ms. Stevens, if you would play that, please.
We agree with that stipulation.
Okay.
I need a police officer in the ambulance at 355 South Yale. You have a police officer down bleeding in the back.
You said a police?
Yeah, you have a police officer down in the back bleeding. He's been nice. She's on Bella to Yale. Do you want me to get a shirt so I can wrap your hand up? Give him both over there. I know what's going on out here. They both give me another shirt.
What happened to him, do you know?
I don't know, but I'm taking my shirt off and I'm wrapping this evening so the face here is up.
Get you over to our paramedics so they can tell you what to do, okay?
He's cut pretty bad, man. His up hand is wide open.
Okay, we're going to get you over to our paramedics so they can tell you what to do to stop the bleeding. Hold on.
Yeah.
Thank you, Your Honor. And with that, our next witness, we would call Kevin Davis to the stand.
Okay.
No.
You can come around here, just watch for the wires so you don't trip.
Thank you, Judge.
A little maze that we have you go through.
Appreciate the ramp.
Raise your right hand. Do you solemnly swear or affirm under penalty of perjury your testimony in this case will be the truth, the whole truth, and nothing but the truth?
I do.
Have a seat and pull yourself up close to the microphone. And you may inquire.
Thank you, Your Honor. Good morning, sir.
Good morning.
Could you please state your name and spell your last for the record?
Kevin R. Davis, D-A-V-I-S.
Could you please tell the ladies and gentlemen of the jury a little bit about yourself?
I'm a retired law enforcement officer. In April of 2021, I retired from the Akron Police Department after 31 years. Prior to my service with Akron PD, I worked for the Summit County Sheriff's Department for 8 years, so I have a total of over 39 years of law enforcement experience. During that time, I worked a variety of different assignments from patrol through the training division and ended my career in the body-worn camera unit of the Akron Police Department as a detective.
You said you're retired?
I did.
How are you enjoying retirement?
I'm busier now than I was when I was working.
Are you married, sir?
I am.
How long?
24 years.
Any children?
Yes, 3.
How many? Oh, any grandchildren?
I have, let's see, 4.
Congratulations. I want to talk to you about when you mentioned that you were an Akron police officer. Can you give the jury a synopsis of the positions that you held while you were a law enforcement officer with Akron PD?
Certainly. I started out as all new hires do in the patrol division. I worked platoon 4, which is 7:30 at night until 3:30 in the morning. I worked that assignment in some of the busiest districts in Akron for a number of years. And then in approximately 1993, a new unit was formed within the Akron Police Department called the Street Narcotics Uniform Detail, or SNUD unit. I worked that unit for about 6.5 years, a variety of different assignments, both in uniform, responding to mostly street-level narcotics trafficking and street crimes in Akron, and also as a plainclothes detective where I, among other things, did surveillance and made hand-to-hand buys of rock crack cocaine primarily. After that assignment, about at the same time with my work with the SNUD unit, I began working for the Akron Police Department SWAT team, where I was an operator and eventually became a team leader and lead instructor. And I also began working collateral duties in the Akron Police Department Training Bureau. After the SNUD unit, after I left that unit, I went into the Training Bureau full-time for about 19 years. I was the lead defensive tactics instructor, a firearms instructor, as well as the lead use of force instructor.
You've provided us a copy with your curriculum vitae to detail your experiences and qualifications. Is that correct?
That's correct.
May I approach the witness, Your Honor?
You may.
Mr. Davis, I'm handing you what has been marked for identification purposes as Defendant's Exhibit 24. Can you take a look at that document?
Yes.
What is that document, sir?
This is appears to be an accurate copy of my curriculum vitae, or CV, also a resume based on my law enforcement experience and my work as a trial consultant and expert witness.
I kind of want to just work through some of those topics listed in your CV, Mr. Davis. When you mentioned that you were with Akron PD, you mentioned that you were involved in the Training Bureau, correct?
That is correct.
And in what capacity were you involved in the Training Bureau?
I was a full-time instructor. My job was to teach basic academy cadets, the new hires within the city of Akron, and also in-service officers, officers that had been working already, veteran officers that came in, rotated through with either firearms training or in-class, in-service training.
Would you do that both in an individual setting as well as a group setting?
I would mostly do individual training on the firearms for remedial shooters, and when we would remediate or bring back officers on the firearms range, primarily it was classroom and hands-on training.
Did you ever train at the Basic Academy?
Yes, I've trained at not only the City of Akron Basic Academy, but the University of Akron Basic Academy and Kent State Basic Academy.
Describe for the ladies and gentlemen of the jury what officers are trained at, or what kind of topics they are trained at during the Basic Academy training.
Well, that curriculum is set forth by the Ohio Peace Officers Training Commission, or OPOTC. The curriculum dictates a variety of different, they call it unit topics, everything from constitutional law through first aid, suspect control, baton, firearms training, room clearing, a variety of different topics. All of that curriculum is set forth by the state. However, at the City of Akron, we always exceeded that, gave more hours than the state minimums.
Can you tell the ladies and gentlemen of the jury what's the importance of training? Why is there so much?
Well, I would argue that we need more, and in that regard, it has continually improved in my career. When I went through, it was only 320 some hours, and now it's over 600 hours, and we're striving to have more training, always striving to have more training. But the reality is that officers do on the street or do in actual incidents what they have been trained to do. And so training is so vitally important, not only to learn the constitutional limits of their use of force, for instance, but also the practical application of use of force.
When you talk about that practical application, how are the trainees trained on the practical application? What types of things do they do in order to be trained practically while they're out in the field?
Well, we start out with the the basics, for instance, of suspect control, how to frisk somebody, how to put handcuffs on somebody, how to control someone when they resist. Everything from that through dealing with people that have weapons, be it knives or guns, what have you. Then we advance through the static training into practical applications or dynamic encounter training. We have padded suits called red man suits or fist suits, and the subjects, the students have to work with a role player in the padded suit to try to control them, etc.
So do you walk through scenarios? Do you give the trainees scenarios and then they have to play out that scenario during that role play type incident?
That's correct. This part of this is what we call inoculation training. So much of law enforcement is dealing with the physiological, psychological, and physical aspects of dealing in a violent confrontation, and they have to work through that, get used to it. In other words, become inoculated to it.
Have you trained supervisors before, Mr. Davis?
Yes, in both hands-on training as well as use of force instructions, or use of force investigations, I'm sorry.
Why is it important, tell the ladies and gentlemen, to train supervisors?
Well, those are your frontline management that respond to the scene, be it an officer calling for assistance in terms of information or knowledge about what they should do a certain call, everything to that through a use of force investigation after an officer has pepper sprayed somebody, for instance, or there's been some type of resisting. The frontline supervisor comes out, conducts an interviews, oftentimes takes photographs, etc., and then comes to a conclusion on whether the use of force was within policy and within the law.
You mentioned you trained with firearms as well. Did you also train trainers with respect to, did you also train supervisors with respect to firearms?
Yes, they were supervisors. Sometimes had their own class or their own training program, but most of the time they were within the group of officers that were at the range at the same time, so yes.
Have you presented at conferences regarding the topics of use and force with regards to whether a decision to use force was reasonable?
Yes, I have done quite a few conferences for the American Society of Law Enforcement Trainers, or ASLET. That organization is no longer in existence. I have trained at the conferences for ILETA, the International Law Enforcement Educators and Trainers Association Conference, CIPHER, which is a defunct organization, which was the Society for the Investigation of Force and Reporting, and as well as Ohio Tactical Officers Association and others.
Have you presented here in the state of Ohio with regards to use of force?
Oh yes, I was an adjunct instructor for OPATA, which is the Ohio Peace Officers Training Academy in Richfield, Ohio, in the northern part of the state. That type of training, I did everything from pistol work, submachine gun training, shotgun training, all the way through use of force investigations.
What about other parts of the country?
Yes, I have trained throughout the country at conferences and for agencies.
You mentioned you were more busy now than you were back when you were a police officer during your law enforcement tenure. Is that because you own a consulting firm now?
Yes.
And when did you start consulting?
I actually have been working as a trainer and a consultant for probably 20 or more years. Previously, I had done more tactical training, i.e. firearms training, SWAT team training, use of force practical application. But as you get older, you start looking at more consulting and doing other things than physical stuff. So I had, now I focus on use of force consulting as well as expert witness work.
You mentioned you you've trained people on defensive tactics. Have you also trained people, officers, supervisors, on non-defensive tactics?
Oh yes, everything from firearms to the legal application of use of force.
Have you authored any articles regarding use of force?
Oh yes, I was quite busy writing for all of the law enforcement periodicals, Law and Order magazine, Tactical Response magazine, Police Magazine, Law Officer Magazine. Unfortunately, a lot of those periodicals are now out of business, but I did write extensively for those venues for a number of years.
Are you associated with any professional affiliations or organizations with respect to law enforcement officers and or use of force?
Yes, I'm still a member of ILETA, the International Law Enforcement Educators and Trainers Association, as well as the Association of Force Investigators.
Have you testified before Mr. Davis as an expert on the use of force here in the state of Ohio?
Yes.
Municipal court?
Correct.
Common pleas court?
Yes.
How about federal court?
Yes.
And when you testified in each of those places, have you been declared an expert before?
I have.
Have you testified in other states, whether it be federally or locally?
Yes.
What are some other jurisdictions that you have testified in?
I've testified in the 10th Circuit Federal Court in Denver, Colorado, and I've been involved in other cases from Pennsylvania, Florida, Lincoln, Nebraska. I was in Spotsylvania, Virginia, Bristol, Virginia last year, so throughout the country.
Quite a few. I want to talk to you, Mr. Davis, about your work case process. How is it that you determine whether or not to take a case during your consulting business?
Well, I don't solicit work. All of my work comes from word of mouth. So I usually get an email, primarily emails from attorneys asking if I'm interested in working on a case. That is usually followed up by a phone call in which I ask for all of the discovery material that is available to them. Now that is a trickle effect. In other words, I get what I can to begin with, but then I go through the evidence as it develops or is presented to me, and first of all give an oral opinion to the attorney whether I believe the case is something that I could help with or is that I believe is part of my expertise, and then that's followed up with a retainer, etc.
Have you reviewed use of force cases and decided not to take them depending on what side the perspective is from?
Yes.
Why so?
Usually because I don't find that the facts are conducive when we're talking about law enforcement use of force, that the law enforcement use of force was not within the law.
Have you examined use of force cases and found use of forces to be unreasonable before?
Yes.
So just because you work on a case, Mr. Davis, doesn't necessarily mean you've formulated an opinion or at that point in time, right?
No. It's, when I start working on a case, you go through it, try to formulate the opinion as best you can in the original stages, but then as the situation develops, that may change. But that opinion is based on the facts and evidence and not on any preformed conclusion or any desire by the attorneys to have their client vindicated.
You mentioned you charge a retainer fee. What is that retainer fee, sir?
$3,500.
Is that industry standard?
I don't know. I think it's cheap from what I understand.
Does that retainer fee come with an opinion attached?
Absolutely not.
Have you worked cases and testified in cases on behalf of law enforcement officers?
Yes.
Have you worked on cases, whether that be administratively, civilly, or criminally, with regards to actions when you were testifying against the officers on a use of force situation?
Yes.
And in our process, when did Mr. Collins and I first reach out to you?
I believe that was in May of 2019 now.
You didn't have the material at first, did you?
No, very little material.
You followed that same exact process whereby we retained you as you had done in normal cases. Am I correct?
That's correct.
When we asked you about the situation first, did you eventually ask us to provide you those materials?
Yes, what frequently happens is that as the case develops, more material is available in discovery and it's forwarded to me. It can be on jump drives, on Dropbox, or just through emails.
And did you eventually receive all of that relevant information that you requested of us?
I don't know if I got everything in the case, but I got a lot of material, so I went through everything that I was presented with.
And did you eventually make us aware of your potential position?
I did, yes.
Did we ask you to prepare a report?
You did.
You charge a fee to testify here, sir.
I do, yes.
What is that fee?
$2,500.
May I approach the witness, Your Honor? Mr. Davis, I am handing you what has been marked for identification purposes as Defendant's Exhibit 25. Take a look at that document, sir.
This is an accurate copy of my report.
I want to walk through your report, Mr. Davis. Before we get to your opinions, I want to talk about the authority behind your opinions. What is the authority that you used to make a decision with respect to a use of force case?
Well, first of all, this authority talks about the officer's authority. In this case, Detective Mitchell was a certified law enforcement officer in the state of Ohio and a commissioned member of the Columbus Division of Police. So he had authority within the city of Columbus to enforce all ordinances, state laws, etc.
Redirecting your attention to the lawful objective part of your report. Describe for the ladies and gentlemen of the jury what type of lawful objectives you're speaking about for taking action in that section.
This goes back to the fundamentals or the foundations for the use of force. In order for an officer to legally use force, they have to have lawful authority. That means that, or a lawful authority, jurisdiction, and they have to have a lawful objective for taking action, meaning they have to be doing something based on the law. In this case, that was the investigation of prostitution and the probable cause that developed to arrest Miss Castleberry for soliciting. So that was the legal foundation or the lawful objective for Detective Mitchell taking action.
I want to talk about the Supreme Court cases you discuss in your report. What are the opinions on which you can derive an opinion, or I apologize, what are the cases that allow you to derive an opinion with respect to whether or not a use of force was reasonable with respect to the Supreme Court of the United States?
Well, there's a variety of different cases. There's Terry v. Ohio, which is about reasonable suspicion and detaining somebody based on reasonable suspicion to believe that a crime has been, is being, or about to be committed, and that person did it. From Terry, we also have what's called a Terry pat-down, or the frisk of outer garments for weapons based on reasonable suspicion. So Terry v. Ohio. In terms of use of deadly force, we have Tennessee versus Garner, which is a 1984 case about the shooting of a fleeing subject, and the Supreme Court ruled on that. Prior to Garner, they had applied the 14th Amendment to use of force cases, but with the Garner decision, they said that use of force was a seizure. And because of that, the objective reasonableness test of the Fourth Amendment applied. From Garner, we then had Graham v. Connor, which was the first time that the Supreme Court applied the Fourth Amendment to the use of non-deadly force. And once again, they said that use of force was a seizure. Now, Graham v. Connor was a civil case. In many states, even to this day, there's conflict about whether Graham v. Connor applies. Well, in Ohio, we now have the White case. That's a 2009 case that was adjudicated in 2015. And what the White case did, State v. White, was apply Graham v. Connor the standards of objective reasonableness. Garner Graham v. Connor, 2 criminal cases in the state of Ohio. So that's State v. White.
So is State v. White the seminal case here in Ohio that experts used to determine whether uses of force were reasonable?
Yes.
I want to move on in your report and talk about the information that you received. You mentioned that you received discovery from us. What kind of information did you review in that discovery?
Everything from the investigative reports, photos of the scene, body-worn camera of the scene, BCI 3D laser scanning and ballistics reports, morgue photographs, coroner's reports, and videotape analysis done by Agent Loomis from BCI, where he connected the audio and video, a variety of other reports, including Detective Mitchell's written report, his audio tape by the investigative detectives, and that's about it.
Have you gone to the impound lot to examine the car involved in this situation?
I did, yes.
Tell the ladies and gentlemen of the jury why it's important to go and examine that car.
Well, photographs only tell you so much, and you can only glean so much. Excuse me. You can only glean so much from a photograph. So going to the impound lot and actually looking at the car, opening up the doors, I was struck by the fact of how tight it was in that passenger compartment. In other words, it's not a very large 4-door sedan. So that gave me better information, excuse me, sinuses, about the movement patterns and the amount of room available in the car for the detective to operate, as well as Ms. Castleberry to move.
When you opened the car door and saw it, what was your initial opinion of seeing it compared to what it had looked like in the photos that you examined?
Yeah, I'm over 6 foot tall. There's no way that I would be able to sit in the back seat of that car as it was left in the impound lot. There was just no room.
Have you visited the scene of this incident?
I did, yes.
Tell the ladies and gentlemen of the jury why that's important.
Well, as part of my report, and I duplicate photos from Google Maps, they can only tell you some. Excuse me.
You need a break?
Do you need a break, sir?
No, I just, sorry, Your Honor. Those the locations on Google Maps. I mean, you can turn the view around and try to get a 3D idea, but it really was quite open. I was struck by how open that area was and how the neighbors and passersby could see where the car was at and subjects in the parking lot of the apartment building, etc.
Now, based on everything that you reviewed, going to see the scene, going to see the car, your training, your experience, your expertise, did you formulate, Mr. Davis, an opinion as to whether or not the use of force was reasonable as it relates to my client, Mr. Mitchell?
I did, yes.
And what is that opinion, sir?
That at the moment that Detective Mitchell used force, that it was within the clearly established law, within policy and procedure of the Columbus Division of Police, and within the standards of use of force in this country by law enforcement.
Thank you, sir. I want to go back in your report, Mr. Davis, to the authority and jurisdiction. You mentioned that you had a discussion in your report about the authority or lawful objective of a police officer in being allowed to use force. Is that correct?
That's correct.
And when you say lawful objection for taking action, do you mean physically touching someone, apprehending them, arresting them? Tell the ladies and gentlemen of the jury what you mean by that.
Well, it could be everything from, for instance, law enforcement officers oftentimes have consensual contacts with citizens. They're working an area, they want to know what's going on, they see someone they don't know on their beat, could be on a sidewalk, excuse me, etc., and they can approach that person and say, "Excuse me, can I talk to you?" And the person can agree and have a consensual contact with the officer, or the citizen can say no and keep walking. At that time, absent reasonable suspicion or probable cause, the officer can't detain the person. if they believe that a crime has been, is being, or about to be committed, that's reasonable suspicion. And they can approach the person and detain the person based on reasonable suspicion. Depending on the circumstances, as I said, that can evolve into what's called a Terry stop or Terry frisk, where they may, for their safety, pat down the person for their outer garments for weapons. If they have probable cause that a crime has been committed, that's based on the elements of crimes in the Ohio Revised Code, then they can detain the person and use force in both reasonable suspicion and probable cause to detain the person. In other words, the person is no longer free to go. In reasonable suspicion, they're not under arrest, but with probable cause, the person is placed under arrest. They're no longer free to go, and the officer may use force to detain that person, handcuff, search, etc.
What did you find in this situation as it relates to lawful objective for taking action?
That Detective Mitchell was on a vice detail, that he had observed Donna Castleberry. I believe he had reasonable suspicion based on her contact with the driver of a truck that he saw pull away. It was a high crime area known for prostitution. He could have, if had he been a uniformed officer, he could have approached and talked to her at that point, and she would have been detained. But working undercover as a vice detective, he then talked to her and developed probable cause based on the elements of the crime, which is soliciting, sex for hire. Once the elements of the crime were met, then he had probable cause to make an arrest.
So was he allowed to charge Donna Castleberry at that point that he had the elements for the offense of solicitation?
Oh, yes.
And at that point, Mr. Davis, once a citizen is under arrest, are they supposed to allow that arrest to happen?
Well, there's no lawful right for a citizen who's placed under arrest to resist arrest. There is no lawful right. And once Detective Mitchell had placed Ms. Castleberry under arrest, she did not have the right to resist.
And when you say once Detective Mitchell placed Donna Castleberry under arrest, what do you mean by that? That doesn't necessarily mean putting her in handcuffs, right?
No, in law enforcement, it's the magic words. You are under arrest. I'm a police officer. He identified himself, showed his police ID, and informed her that she was under arrest.
Is she allowed to say, "I don't believe you're a police officer, so you're not putting me under arrest"?
I don't know whether she's allowed to say. They say a lot of different things, but she's not allowed to resist arrest.
So is she allowed to be non-compliant?
No, she's not allowed to. In other words, resist being handcuffed, etc. She's not allowed to do that.
And at that point, Mr. Davis, what are Mr. Mitchell's obligations? Is he allowed to reach over and take her into custody by handcuffing her?
Objection to all the leading questions, Your Honor.
Yes, he is at that point in time. That would be his decision on whether he wanted to handcuff or not based on the circumstances. For officer safety, it's always advisable to handcuff people. In these situations, it's difficult because trying to handcuff somebody primarily behind their back in the passenger seat of a vehicle is not an easy thing to do, especially if they're resisting. But he is allowed and should handcuff subject to control that person to reduce the threat against him and also to improve the safety of Ms. Castleberry.
Is there anything else, Mr. Davis, with regards to the lawful objective for taking action in this situation?
No, that everything is clear that he had probable cause to make a lawful arrest for the crime of soliciting.
I want to direct your attention to police-involved tactics. Can you tell the ladies and gentlemen of the jury what kind of tactics, if any, are allowed in the analysis of use of force with respect to either Graham or Garner or Terry v. Ohio?
Well, tactics refer to what an officer does. The tactic can be, for instance, things like using cover, creating distance, de-escalation is a tactic. The problem with these things is they're subjective in nature and have nothing to do with the core transaction of the use of force. We don't judge, and the prosecution's expert, Uri Patrick, has said in his book that the actions of an officer prior to the use of deadly force are irrelevant. And the reason for that is because they're so subjective. Could he handcuff? Yes. Could he not handcuff? Yes. Could he get cover? Yes. Did it make the use of force bad if he didn't use cover? No. Could he have gotten or created distance? Possibly. Did it make the use of force bad because he didn't? The answer is no. So tactics are very subjective, but have nothing to do with the examination of the use of deadly force at that moment.
Are you aware, Mr. Davis, of any policies back in 2018 regarding whether an officer had to take a person to jail if they had warrants?
It's my understanding in Franklin County that it was policy or Columbus Division of Police to take a person into custody if they had a warrant.
I'd like to move on to the next part of your report. I think you detail it circumstances. You claim that the circumstances are tense, uncertain, rapidly evolving. Why do you include this type of analysis in your report?
This comes directly from Graham. So what I try to do in my report is deal with many of the issues as outlined in the Graham decision and work from there. Not all of the circumstances were tense, uncertain, and rapidly evolving. We can hear on the audio tape that there was a conversation between Detective Mitchell. He was trying to, he provided his ID, provided other paperwork to Ms. Castleberry to assuage her fears at that point. But at some point, when he makes the decision to handcuff her because of her behavior, then the circumstances change. And certainly the circumstances are tense, uncertain, and rapidly evolving once she cuts Detective Mitchell.
Who changed those circumstances, Mr. Davis?
Ms. Castleberry changed those.
You mentioned he went through various steps in order to try to calm Ms. Castleberry down. What would you classify that in terms of Mr. Mitchell's police action?
The big buzzword today is de-escalation. Although ultimately the use of deadly force is based on his reasonable perceptions at the moment that he fired, we look at totality of the circumstances and we find that he attempted over a period of time through calming dialogue, the showing of his police ID, the showing of other paperwork, to once again assuage her fears and to de-escalate the situation. Matter of fact, he said, hey, listen, I'm not going to handcuff you at some point, and that once again an attempt to to de-escalate the situation in terms of use of force.
Is answering her questions a type of de-escalation?
Certainly, a dialogue is an important part of de-escalation.
When he tells her, I will not take you in as long as you don't have any warrants, is that a type of de-escalation?
Yeah, to once again reduce her fears. Ms. Castleberry was not new to law enforcement contact, and she knew that if she cooperated, and she knew the process.
Speaking of the process, Mr. Davis, when he tells her, I'm going to cuff you for both your safety and my safety, is that a normal process in terms of arrest that you have seen based on your training and experience?
Yeah, those words to that effect are used thousands of times and every day in law enforcement. Once again, telling the person, this is what I'm going to do, and this is why I'm going to do it.
What about resistance? Is resistance common?
I'd say the majority of arrests, vast majority of arrests, have no resistance. There is a gradation in terms of resistance that we see. We see verbal noncompliance or verbal assaults. That's part of resistance. We also see resistance during the handcuffing procedure. That's pretty common in terms of resistance that occurs. In law enforcement, we try to train officers to be ready for resistance once the first handcuff is applied, because for whatever reason the suspect realizes that, hey, I'm going to jail or I'm being arrested at that point, and they tend to pull away or resist the handcuffing procedure. So we have majority of incidents, even in this type of prostitutes arrested for soliciting, are completed without any type of resistance or without any type of use of force.
Who does the resisting, Mr. Davis, the officer or the suspect?
Well, the officer reacts and has to respond to the resistance displayed by the subject. So officers respond to what the suspect does. Suspect cooperates, then they're handcuffed, transported, paperwork is done, and they're either booked into the jail or released on a summons. If they resist arrest, it can escalate up to including deadly force.
Once there is resistance, Mr. Davis, who is the aggressor at that point?
Well, the officer isn't the aggressor. The officer's job is to control. The suspect resists arrest and is the aggressor. And certainly in this case, Ms. Castleberry was the aggressor. She cut and seriously wounded the detective at the beginning stages of the encounter with a knife that he didn't even know she had in her hand.
Once she brings that knife into the equation, Mr. Davis, how did you view that with respect to your analysis?
That's a deadly force situation. Certainly, even standing on the street is a dangerous situation. And once again, the prosecution's expert, Mr. Patrick, talks about in his book and previous testimony the lethality of a knife. So standing out in the open is a dangerous situation when you're confronted with somebody that's cutting or attempting to cut you with a knife. In the close confines of a vehicle where you can't maneuver as you normally would, you can't get a base, for instance, stand up and be able to develop power, etc. A very, very dangerous situation.
Who created that deadly situation?
Ms. Castleberry.
Why so?
Because she chose to resist a lawful arrest. That's number one. She had no lawful right to do that. Number two, she chose to access, open, and cut Detective Mitchell with an edged weapon. She chose to place her back up against the dashboard and shove her foot against his throat to the point where he was almost rendered unconscious. And then she chose to continue to resist and to not comply with with the instructions or with the situation, to submit to lawful arrest.
When someone decides to use a weapon against a police officer here in the state of Ohio, is that a crime?
It is.
Tell the ladies and gentlemen of the jury what kind of crime that is.
Normally in this situation would be felonious assault.
Now, after you're on the receiving end of a felonious assault, what does training dictate to do in this type of situation?
First of all, survive, to be able to keep from being seriously wounded or killed during the encounter. That's number one. And number two is to try to control the subject, to stop the person from continuing to assault you.
When you're close to that knife and somebody has already cut you, what did training dictate that Officer Mitchell do in that situation?
Well, this situation is an anomaly in that when we train law enforcement officers in firearms, for instance, we do so at the range. It's a flat range. Most of the time it's well lit. The target's in front of us at a known distance. It may turn or a tone may go off to indicate when to fire, but there's not any training that's required in the state of Ohio on how a detective should confront a female offender who has a knife, who is seriously wounded, and be able to maneuver, be able to shoot, be able to stop the threat in a vehicle. There's just no training like that.
Was Mr. Mitchell's actions of trying to grab the knife, was that reasonable in this situation?
Grab the knife or grab the hands, yes, to attempt to keep from being cut, yes.
I want to talk to you about using a knife, Mr. Davis. What type of skill does it take a person to use a knife against a police officer?
Well, unfortunately, in my career on the street and SWAT, I've seen countless numbers of stabbings, slashings, and edge weapon attacks. It takes no skill whatsoever. It's one of our basic tools as human beings that we develop, but also one of the basic weapons that we've been facing or have been used against us. It takes no power, no technique, no training, whatever. All you have to do is take the sharpened point, of whatever edge weapon it is, shove it into your victim, or take the edge of the blade and slice or cut the victim, or to chop or hack or whatever. So it takes no skill, takes no power. I've seen small juveniles commit felonious assault, serious wounds with edge weapons. Somebody that was smaller in stature than Miss Castleberry.
And so I think you mentioned Miss Castleberry's size in your report, that she was 5'4" and 115 pounds thereabouts. Why did you mention that in regards to her use of the knife?
Well, once again, that's how tall she was and how much she weighed. So if it does need to be considered, but when you're talking about a deadly weapon, for instance, a gun or a knife, that's the great equalizer. I mean, you know, the old notion about guns is that God made men, but Sam Colt made them equal, meaning that guns are an equalizer. With edge weapons, also, it doesn't regard. I've seen very, very small people totally eviscerate victims with edge weapons. In other words, basically fillet their abdomen open. So it takes no power, no strength, no skill. And her size and weight did not factor in at that point.
What does the law say, Mr. Davis, about perspective in this situation? Whose perspective are you supposed to be viewing this from?
From the perspective of Detective Mitchell. The question is at the moment he used force, would a reasonably prudent and well-trained officer in those exact same circumstances have used that amount of force?
I want to switch gears and talk about the shots that are discussed as part of your report. You discuss a concept called ambulation. Tell the jury what being ambulatory means in reference to the shots here that you analyzed.
Well, I specifically used the term ambulation after death or ambulation after a serious wound, pardon me. Mr. Patrick, the prosecution's expert, uses this extensively in his book and talks about the same concept. The reality is that a subject can receive a mortal wound, a non-survivable wound, and still stay in a fight or still stay the aggressor attacking 10 to 15 seconds, and Mr. Patrick even says up to 5 minutes. There's very many variables there, but that concept is that you can shoot somebody, literally take the heart out with a gunshot wound or stab into the heart, etc., and that person can still stay up, mobile, and a deadly threat until they finally drop from loss of blood pressure, etc.
Do we know what shot here, Mr. Davis, was the mortal wound?
Well, the torso shot, which hit Miss Castleberry's heart, was the mortal wound.
Do we know if that shot occurred in shot number 1 through number 6?
No, that has never been determined to my knowledge.
Typically when officers are trained to fire a weapon, are they trained to fire at the weapon or the hand that's holding the weapon?
We're lucky if they hit the center torso of a subject. Surprisingly, and contrary to what you see in TV and movies, gunfire by officers is not that accurate. In many agencies, only about 25% of the rounds they fire hit their intended target. And that's even at close range. The majority of police gun shootings are within 21 feet. And even at that distance, officers don't hit. And the reason for that is many, the subject is usually moving, the officer may be moving, the circumstances leading to what we call sympathetic nervous system reaction or fight or flight, which degrades performance under stress. All these things can factor in. But even in the most highly trained agencies, 50% of rounds that hit their intended target are pretty good.
What are they trained to aim for, Mr. Davis?
That would be center of mass, or the largest area of the target, the subject that is presented to them. So if they're frontally aligned to the person, it would be the center torso, primarily where the heart is and where the major organs lie. But if they're at their side or have a side target, it would be that area. It could be, depending on what the circumstances are, if they only have the thigh of the subject, they're trained to shoot the center of the mass of the target that they have available to them.
The rest of your report talks about a factor discussion. Are these the factors that we were talking about earlier, Graham and White?
I'm sorry, factors?
Yes.
The Graham factors are elucidated or mentioned by the Supreme Court in the Graham decision. That's usually severity of the crime at issue, whether the suspect poses an immediate threat to the officer or others, and whether the suspect is actively resisting arrest or attempting to evade arrest by flight. However, those are not, it's not what's called an exhaustive list. In other words, there's other variables that factor in under totality of the circumstances, excuse me. In the White decision, they talk about even more factors that can be considered, but once again, not an exhaustive list.
And did you base the rest of your report on the totality of circumstances as well as your decision here?
Yes.
And when you're examining the totality of circumstances, whose perspective are you to use in order to examine the totality of the circumstances?
Detective Mitchell's the actual officer that was involved.
So if I'm correct, you're supposed to put yourself in the shoes of Officer Mitchell and experience those things as they were occurring to him at that time?
That's correct.
And Mr. Davis, what did you find in regards to the totality of circumstances as you're standing in an officer's shoes, specifically Andrew Mitchell's shoes, at the time that he was experiencing the knife, the choking? What did you find with respect to the use of reasonableness?
I found that it was a chaotic, extremely violent, dynamic encounter within the close confines of a vehicle. It was a deadly situation. Had Detective Mitchell, for instance, his hand slipped from the arm holding Ms. Castleberry's wrist or arm that contained the knife, that he could have sustained a mortal wound. That at the time he made the decision, after he was almost rendered unconscious by her shoving her foot in the side of the neck, that when he made the decision to let go and move for his firearm, that was a serious circumstance that, had it gone the other way, Detective Mitchell had possibly been killed or seriously wounded. And that the time that she moved into the back, that Detective Mitchell makes a statement or in his report talks about he was afraid that she was going to slit his throat from behind. He had to divert his attention to grab and access his duty pistol, and during that period of time, very susceptible to an attack by Miss Castleberry. When he comes back, once again, she's now moved past him or moving past him into the back seat. Very hard to accurately deliver gunfire to stop her, and she's moving chaotically in the back seat, making a very difficult target. So all these circumstances exist, and in that I find that his actions were once again within clearly established law or reasonable based on the totality of the circumstances.
I want to break that statement down, Mr. Davis. Did you rely on the Graham factors and other factors in State v. White in order to come to that decision?
Yes, I considered them, used some, but not all of the White factors, for instance, apply.
I want to talk about the Graham factors. What is the first factor that you analyzed?
The severity of the crime at issue.
Tell ladies and gentlemen of the jury what you found with respect to the severity of the crime at issue from the incident on August 23rd, 2018.
Well, what we're talking about is the severity of the crime at issue referenced the seizure, referenced the use of force. And at that point is when Detective Mitchell is cut. Up until that point, he's trying to handcuff Ms. Castleberry, is verbally defiant and apparently pulling away, takes the handcuffs, puts them outside the window, etc. All that is resistance, but we have a deadly threat. We have a deadly circumstances once she accesses her knife from wherever, opens it up and cuts him. then that is a felonious assault. That's a deadly assault on a police officer. She's, first of all, not allowed to resist by pulling away. That's against the law. And it certainly escalates by her actions into felonious assault.
So what is the crime at issue here that you're to analyze, Mr. Davis?
Felonious assault, or the use of the knife and the assault of the detective. That's the circumstances that we're talking about in terms of the use of deadly force.
It's not soliciting?
No. I mean, a situation, and oftentimes this happens where law enforcement officers try to arrest misdemeanor subjects. Unbeknownst to them, that person is a wanted felon and armed with a gun. It could be something simple like jaywalking. You try to arrest a person or cite a person for jaywalking. Next thing the officer knows, the subject is pulling a gun and shooting at the officer. He's not dealing with a jaywalker. That's not the severity of the crime. The severity of the crime is the attempted murder or the felonious assault.
I'd like to discuss the second factor. What is the second factor that you base your conclusion on with respect to Graham?
Whether Ms. Castleberry was an immediate threat to Detective Mitchell of death or serious bodily harm.
What is your opinion on that, sir?
Oh, that's not only, it rises above his perceptions that she was an immediate threat. There's no doubt that she was an immediate threat. She seriously wounded him by cutting his hand open with an edged weapon. And there's no doubt that that was an action taken, so that it was an immediate threat. Had he, once again, not controlled her arms, we don't know what the outcome would have been.
Did you find this threat to be ongoing?
Yes, throughout the encounter until Ms. Castleberry is finally wounded to the point, or her body, based on blood pressure, loss of blood, etc., they call it exsanguination or blood loss, where she finally succumbs to her wounds or stops resisting.
What facts did you review that would lead a reasonable officer to believe that the threat was in fact ongoing?
Well, primarily we have the videotape, although unfortunately the videotape is very hard to see. We know there's movement. We know, based on the facts and evidence, that Ms. Castleberry did have a knife, did cut the detective. Those are facts and evidence. We know that the situation started in the front seat, ended up in the rear seat, and that's where the shooting took place. And we have Detective Mitchell's statements about what he saw, what he perceived, what he felt.
What happened to your knowledge after the after the knifing incident?
Well, that happened early in the encounter when he didn't know that she had a knife. Apparently it was palmed or something he describes to a detective, so he didn't know he'd been cut until afterwards. Then when he tries to grab her arms and control her arms is when she maneuvers, somehow gets her back up against the dash and shoves her foot into his neck. Once again, he's seatbelted in, and this is extremely dangerous because you know from ultimate fighting competitions or martial arts or whatever, that rendering somebody unconscious through a choking or through a neck restraint or what have you leads that person to can become unconscious and even more susceptible to attack.
Why is that relevant here, Mr. Davis?
Well, because Detective Mitchell could not allow himself to be rendered unconscious. As a matter of fact, in his statements, he talks about feeling that he was going to black out. Once again, because of that, making the decision to let go. When he let go, Miss Castleberry still had the knife in her hand. That's his statements. And also, as she's moving from the front seat to the rear seat, he says that she still had the knife. He was aware of that. At that time, she was right next to him. She'd already cut him. It was reasonable for him to believe that she was a threat of death or serious bodily harm.
And at that point, was it reasonable for him to shoot?
Oh, yes.
Why, or does it matter if Detective Mitchell ever suffered another serious slash or wound?
No.
Why not?
Well, in the use of force, and once again, excuse me, the prosecution's expert, Mr. Patrick, talks about, in one of the cases, the White case, was Mr. Patrick was used as an expert to testify in that case about Officer White's behavior. Officer White shot a subject by the name of McCloskey who didn't have a gun. And Officer White's statement was that McCloskey was making the motion towards his waistband to what he believed to access a gun, and Officer White fired. And Mr. Patrick testified in that case that he didn't need to have a gun, that his perception of the threat of death or serious bodily harm was enough based on the law. And now we know that the White case is law in the state of Ohio.
So an officer only has to perceive that a person is a deadly threat. Is that correct?
Oh yes, he just has to perceive it. It's reasonable under this situation. We have no evidence that Detective Mitchell knew when she let go of the knife. We know that the knife was found somewhere around the driver's seat, but there's no evidence to suggest that she could have dropped it after the final shot. We just don't know.
Now, at the point he feels as if he's going to lose consciousness, he releases his hand. What, in your experience, then, would an officer be trying to do with respect to deadly force? What's he focused on at that point?
Well, he's focused on accessing his handgun. The problem with that is handguns are usually concealed or carried on the strong side of an officer at belt level. Here we have a situation where the vice detective has decided to put his handgun at the side of the driver's seat. This is not something that you train for. And all of the studies, all of the times that we look at in terms of response time are an officer coming from the holster with the handgun already out. In this case, the detective had to turn, unbuckle his seatbelt, we know he opened the door, access his handgun, and then turn. And his statement is that he fired first with his left hand, pivoted, then his right hand, and then both hands, I believe, on the final shot. But this all takes time. This is not something we train for, unfortunately, and not something you can understand the time frame involved because of the movements of the detective to access his gun and deliver an accurate fire on target.
Was that action taken by Detective Mitchell reasonable?
Oh, yes.
Was it reasonable for him to fire across his chest, kind of turning his head?
Certainly. I mean, there's no, once again, we talked about tactics being subjective. There's not any training in the basic academy or in service that I'm aware of that teaches officers how to shoot at a deadly threat behind them in the seat of a vehicle. There's no training. So the object is to get the muzzle, the barrel pointed towards the threat. And it was my understanding that the first shot or a couple shots were to get Miss Castleberry off him because he felt that she might slice his throat.
In your opinion, Mr. Davis, was there any type of reassessment going on here?
Well, it's continual reassessment, but you know, this term reassessment is an interesting notion. Mr. Patrick in his book talks about, you know, in the book only uses the term reassessing or reassess one time. And he talks about that in a derogatory fashion. For instance, there is a group called PERF, or Police Executive Research Forum, and part of their recommendations is that officers continually, you know, think and reassessing, et cetera. There are a variety of different components there. But the problem is, and Mr. Patrick says this is beyond the standard of Graham v. Connor objective reasonableness. In other words, reassessment is not a part of Graham nor a part of White.
Now, with respect to this second factor, whether the person posed an immediate threat, does an officer have to be certain that the suspect has a weapon?
No, Mr. Patrick, as I stated before in the White case, said that you know, his perception that he was facing death or serious bodily harm is enough to allow him, if it's a reasonable perception, to use deadly force.
What if the officer doesn't see the weapon?
Well, once again, you know, there are a variety of different circumstances especially with subjects that are moving in this manner, very hard to see. But he knows that she had a knife. He knows that he had been cut. So he had more than just his perceptions. He had probable cause based on actually being cut that she was a deadly threat.
And was that reasonable for him to perceive at that time?
Oh, yes.
The next part of your report talks about the third gram factor. What is the third gram factor?
Let's see, whether the person was actively resisting arrest or attempting to evade arrest by flight.
Walk the jury through that factor and how it applies to the facts in this case.
Once Ms. Castleberry began resisting at the handcuffing procedure, she continued to resist and turned into assaultive behavior in short order by once again accessing, opening, and cutting the detective with the knife. That's felonious assault. That is a fact and evidence. At that point, the movement in the front seat, she maneuvered after he grabbed her arms to place her foot against his neck. And this is extremely dangerous, as I said, because you have a detective who's already been cut. And if you've ever been cut accidentally, even in the kitchen, you recoil and the pain factors, etc. Blood is flowing, making gripping slippery on her hands and arms, etc. Blood pressure begins to drop a little bit. Heart rate increases because you're in fight or flight, all of these things. And then when he's almost rendered unconscious, he makes the decision to save his own life and let go of her arms and turn and access his firearm, knowing that she still had the knife and knowing that as she moved next to him that she was still armed with the knife. This continued throughout the encounter until she was finally stopped.
You said she moved next to him. Are you aware of where Donna Castleberry was found in the vehicle?
Yes, based on the body-worn camera video.
Now, is that a change in circumstance, Mr. Davis, that you took into account for purposes of your opinion?
It's not a substantive, what I call a substantive change, because it was within touching distance. There is no time during this encounter when Donald Castleberry was beyond arm's reach of the detective. All she had to do with the knife was to extend her arm and shove the knife into him or slice him, or etc. So during that entire encounter, she was within touching distance.
I want to switch gears and talk about human factors. I believe they're listed in your report. How do human factors impact an officer's perception with respect to what is occurring in the car?
When we talk about human factors, and once again, Mr. Patrick deals with these in his book as well, we're talking about the impact, physical, psychological, physiological impact of stress on the human being in times of peril. And this is commonly called what you might know as fight or flight. You may have experienced these things, say you were in a traffic accident, or not even in an accident. You're driving in downtown Columbus and a car pulls out in front of you and you slam on the brakes. And that's probably an occurrence here, like most cities. You may find yourself that you were narrowed into the car in front of you. You may be shaking afterwards. You may have jammed on the brakes, which is why ABS brake systems improve performance, because we don't pump brakes in those times. We're incapable of those types of actions. So these human factors, whether psychological, physical, or physiological, impact our performance. Also in that we have what's called action response, which is how time and distance impacts performance.
Are you familiar with the term perceptual unnarrowing?
Perceptual narrowing, yes.
Tell ladies and gentlemen of the jury what perceptual narrowing means.
Well, as this study advanced, we used to call it tunnel vision, where you tunnel in on something. Tunnel hearing as well, or auditory exclusion, where we're not hearing as well. Those types of things have changed to perceptual narrowing. The science now says that when something happens, when a threat presents itself in front of me, It's not that I don't see the things out to the side, it's just that my brain filters them out as unimportant. In other words, if I have a deadly threat in front of me, what's to the side or to the rear is not important to my brain for survival. Same thing with hearing. And once again, Mr. Patrick talks about this in his book, where officers repeat verbal warnings. We have these tape loops that officers get in sometimes where they say, get down on the ground, get down on the ground, and they repeat the thing over and over again. Or they don't hear their partner yelling at them because, and when I say don't hear, they're hearing it, it's just their brain says this is not important. So perceptual narrowing has to do with not only the sense of vision, but also the sense of hearing.
Tell ladies and gentlemen of the jury how you took tunnel hearing, perceptual narrowing, into the account here when analyzing this case.
Well, there's other factors involved in what went on auditorially inside the vehicle, but certainly there's nothing to say that that the detective heard what Ms. Castleberry said, especially when he's focused in on his response. He's focused in on shooting. And also, when you have gunfire inside the confines of a vehicle, that is an overwhelming sense. Microphones, for instance, oftentimes blank those sounds out. We may later on suffer ringing in the ears afterwards, but not even realize that shots were fired. For instance, in a shooting that I was involved with, the shots from the suspect at us were very loud, but our shots toward the suspect were muffled. So there's a lot of interesting things that take place that you may or may not hear shouts of warning, shouts of suspect, and you may not even recall what you said.
So what is your opinion with respect to if Andy Mitchell perceived the words uttered by Donna Castleberry in this situation based on your training, experience, and expertise?
It would be up to his testimony as to what he recalled, hearing, but it would be understandable that he didn't hear it under those circumstances.
Would it be reasonable?
It would be reasonable, certainly based on, once again, that perceptual narrowing, especially once the gunfire started and his focus on shooting. Once you're focused in on your action, you're trying to be effective or trying to stop the deadly threat in this circumstance, then other things are filtered out by the brain as unimportant.
Another human factor you mentioned, Mr. Davis, is close proximity. Tell the jury what you mean by close proximity.
Once again, this has to do with action response. Everything at close range is perceived by us as a deadly threat. In other words, when we're confronted by a subject in a surprise attack with a knife, in this case, or as a gun, everything is an emergency because our brain does not perceive that we have enough time to react and respond. We're rushed, we're panicked because of these circumstances. Even a police officer who's been trained can still suffer these effects. An officer could have their attention be diverted or them not be paying attention. They could be having a bad day. They could be thinking about other things. All of these things factor into leg time and mental leg time. And oftentimes in close, unfortunately, we see officers say to suspects with their hands in their pocket, take your hand out, take your hand out. And when the suspect has a gun and takes their hand out, they're shot, the officer is shot before they realize the suspect has drawn a firearm and shot them. That's how fast action is versus response and mental leg time.
I want to focus on that for a moment, Mr. Davis, specifically the shot cadence here. What did you find in regards to the shot cadence here of Mr. Mitchell?
Well, it is what it is. I mean, those are the shots fired, the amount of time that he's taken. What we can say is that when we examine cadence of fire, we have to examine circumstances. And that is, the time delays involve a lot of different things. Once again, we talked about the difference between drawing from a holster and reaching next to the driver's seat getting the gun, removing it from the holster, shooting with the left hand, hand change into the right change, or to the right hand, shooting with the right hand and turning in the seat to be more effective. All of those things are going to add time. When we're dealing with somebody at 12 feet in front of us that's a deadly threat and we're drawing from a holster, those types of situations don't translate to this type of situation. This is completely different based on the circumstances.
What's your opinion based on the circumstances with respect to the reasonableness of the shot cadence?
That it is what it is. He perceived a deadly threat until the last round was fired, and that decision to fire was reasonable based on the circumstances.
Do you know are you familiar with the term soot and stippling?
Yes, I've gotten advanced training in shooting incident reconstruction, and I know the terms.
Tell the jury what soot and stippling means and how it relates to proximity in this situation.
Well, and what we have in stippling is normally about, will occur, and what it is the unburnt powder and particulate that comes out after the bullet goes out in a cone-shaped pattern, and usually it's out to about 18 inches. So from 0 to 18 inches, you're going to see various degrees of stippling. The closer the barrel is to the skin, it could be clothing, what have you, you're going to see a ballistic mark, a pattern, a cone-shaped pattern.
Did you say that distance was 0 to 18 inches?
Normally, yes.
I want to switch gears and talk about another human factor that you take into account in your analysis, specifically memory. Based on your training, Mr. Davis, is it reasonable for an officer to recall every single thing that has happened or not happened?
No, this is common knowledge in law enforcement. Mr. Patrick, once again, the prosecution's expert, deals with this in his book about memory. A friend of mine, Dr. Alexis Artwall, has done extensive studies in terms of what officers remember after shooting incidents, and the memory does not work like a VCR. It's very fragmented. It depends on experience, on training, on the circumstances. There's a huge component with human memory, and oftentimes memory may improve after an encounter. For instance, we recommend that officers are not interviewed directly after the incident, that there's a delay for a couple of sleep cycles. They tend to remember more once the stress chemicals wear off, the adrenaline, noradrenaline, etc. They tend to remember more. However, over time, that memory can deteriorate. This has been a number of years since the shooting took place. It wouldn't surprise me that Detective Mitchell's memory is worse now than it was, several days or weeks right after the incident.
In your experience, Mr. Davis, is it reasonable for an officer, or in this case, Officer Mitchell, to not remember a door being open?
No, there is a variety. I worked a case for the Akron Police Department in which several officers fired, and it was compelling because none of the officers had an accurate recollection of the events of the shooting. All of them had distorted memories.
So in that distorted memories, is it reasonable for Officer Mitchell to be able to recall every single thing that may or may not have happened on the video?
No. It depends on what we're focused in on as well. For instance, the door being open was at the time that he was accessing his firearm. Does he have a recollection of that, or getting the gun, drawing the gun, and shooting? One would say that, based on the way the brain works, the door being open was a trivial thing, to consider based on shooting to save his life.
You just mentioned about the door being open. Does Officer Mitchell have an obligation to retreat if the door was open?
No. There is no lawful requirement for an officer to retreat, or what's called a tactical retreat. This may or may not happen based on a decision by the officer, but there's no lawful mandate for them to retreat.
Does that diminish the threat if the door was open?
Not with Miss Castleberry armed with a knife to his rear, no, not as based on his perception that she was a deadly threat.
Does Officer Mitchell have to wait before force is used on him again before employing deadly force?
No, matter of fact, he doesn't even have to be sure that Miss Castleberry has the knife. His perceptions just have to be reasonable.
Tell the ladies and gentlemen of the jury what preemptive force means.
This is based on an article from Tom Piotrowski, who is I believe he's now retired from the FBI, a special agent with the FBI, and this was published in the FBI Bulletin. And once again, Mr. Patrick, I believe, quotes Mr. Piotrowski in his book. Preemptive force means that we don't use force, or an officer doesn't use force, or in this case, Detective Mitchell didn't use force because of what Donna Castleberry did. He used force to stop her from feloniously assaulting, cutting him, stabbing him, etc.
Based on your review, Mr. Mitchell, is that the type of preemptive force that was used here before each and every shot?
Yes, yes.
Based on your review here, Mr. Davis, is it based on your experience and review, did Andy Mitchell continue to keep firing?
No, once Miss Castleberry stopped, he stopped shooting.
What did you determine as to whether Donna Castleberry presented a threat?
I'm sorry, can you ask?
I apologize, that was a terrible question. With respect to the threat, what did you determine with respect to the threat, if it was ongoing or not ongoing?
Once again, Detective Mitchell's statements were that at the point where, well, he certainly knows that Donna Castleberry has a knife. He just got cut. He knows that she's resisting by shoving her foot in the side of her neck. He made the decision to save his life and let go of her hands or arms and access his firearm. And he knows at that point that she still had the knife in hand as she's moving past him. But his statement is he was in fear that she was going to slice his or slit his throat from the rear seat, and that was a reasonable fear based on the perceptions. She was moving chaotically, very hard to see, very tense, as we say, tense, uncertain, and rapidly evolving situation that was a deadly threat.
Thank you, Mr. Davis. I want to switch gears and talk about Uri Patrick for a moment. You've already discussed some of what Uri Patrick in his book had authored, and I think some prior testimony as well. Have you read Uri Patrick's report in this case?
I have, yes.
Have you read his book?
Several different editions. I believe I own 2 editions.
It's called In Defense of Self and Others, right?
That is correct.
And what did you find with respect to Uri Patrick's report in this case in comparison to other works that he has authored and or prior testimony?
I was confounded by several different things that Mr. Patrick said in his report. For instance, he uses the term necessary or reasonably necessary no less than 9 times in his report. And that is not a Graham factor, and that's not a White factor, and that's not in keeping with his testimony in White. In White, he specifically said that later on we may find that force was not necessary, but if deadly force is based on the officer's reasonable perceptions that the subject had a deadly weapon, then it's reasonable, then it's within the law. He in his book and the Laquan McDonald case talk about the lethality of a knife, and he says he compares edge weapons and guns, and how the public may not believe that a person with a gun is a deadly threat, and that it's even worse when we're talking about a person with a knife. But clearly, within touching distance, as Mr. Patrick says, that Donna Castleberry was a deadly threat, armed with the knife. And there are other areas that I disagree with his report. As I said before, the reassessment. It's a quandary to me where he talks about reassessing prior to shooting, but in the book he is very derogatory in that when he refers to the perf standards about that, he says that that's not in keeping with the legal standards of objective reasonableness.
Mr. Davis, in your report and analysis, did you consider suspect intent?
Well, I consider what I call manifested intent. In other words, we're not mind readers. We don't know what Donald Castleberry was thinking. We only know manifested intent, which is what she was doing. And what she did was feloniously assault the detective, resist arrest, feloniously assault him with a knife and presented a deadly threat. That is a fact and evidence.
Based on your training, experience, expertise, what did you find with respect to my client's decision to use force on August 23rd, 2018?
That it was a reasonable use of force based on his perceived threat of death or serious bodily injury based on the totality of the circumstances.
May I have a moment, Your Honor?
You may.
Thank you, Mr. Davis. I have nothing further at this time.
Ladies and gentlemen, at this time we're going to take a break. Carla will want one. Hold on. Do not discuss this case among yourselves. Do not permit anyone to discuss it with you or in your presence. It is your duty not to form or express an opinion on the case until it is finally submitted to you. About 15 minutes.
All right.
I've looked over your CV. Obviously, we've discussed this at a prior hearing, and you list a lot of cases in your CV, including things that happened while you were still working at Akron PD, right?
That's correct.
So cases you were involved in while you were there, and then you have some cases where you submitted reports, things didn't go to trial, right?
Correct.
Cases where you may have submitted a report and it was settled or was a civil case.
Maybe ongoing as well, yes.
Okay. And with respect to criminal cases where an officer used deadly force, how many times have you testified as an expert at that trial in that specific field? Let's not include what we're doing in this case here.
I would have to refer to my CV.
You can't tell us how many cases you've testified in, that you've been in court, declared an expert, talking about matters like this?
Well, I want to be accurate, Counselor. I don't want to guess. I don't have an accurate recollection as to the number of times, ma'am.
Mr. Davis, we talked about this very topic last year, did we not?
We did, yes.
I asked you that very question then, didn't I?
I can't recall, but okay.
And you still can't tell me. One or two, maybe?
Oh, it's more than that, I would think, but a number of them, yes.
That you have testified whether or not an officer's use of deadly force was reasonable or not in a criminal trial.
Or testified in a...
No, I asked that specific question. How many times?
I would refer to my CV. Would you like me to?
Sure, we'll wait a moment.
I believe 4 times, including prior testimony here.
Which cases are those, if you would?
Well, obviously, the prior case here, that would be State of Ohio v. Jacob Baker. That would, another one would be,
Well,
I'm sorry?
are you looking at your report to get these? You're looking in the air.
Well, I just looked, and
Okay.
I'm telling you the answer.
Jacob Baker.
All right. In the 10th Circuit, that would be Estate of Dion Damon versus City of Denver.
You're saying you testified in a criminal,
Oh, I'm sorry, that was a civil case.
okay?
The Jacob Baker, this case, excluding the civil case, that would be, what, 2 cases, 3 cases?
Besides this case, that would be one case then, right?
Jacob Baker, correct, actual
Jacob
trial at, yes.
Exactly, thank you. And in these cases, the majority of the cases in which you have acted as an expert and given some opinion, civil or criminal, whatever these may be, they were almost entirely in favor of the officer, claiming the officer acted reasonably, right?
Those were the clients that hired me. I can only give opinions in cases where attorneys retain me.
So you haven't been retained by the prosecution, correct?
No, that's incorrect. I worked prosecution cases in Portage County, Colga County, Summit County, so several different
You haven't
counties in
testified
Ohio.
in a criminal trial on behalf of a prosecutor to say an officer acted unreasonably.
Not officer cases, but I have testified as an expert for prosecution in cases in Ohio.
In use of force, general use of force matters, right?
In murder cases, a variety of different cases.
And you know who Yuri Patrick is, right?
I do.
You know who John Hall is?
I've actually met John Hall and corresponded with him. That's the co-author of the book In Defense of Self and Others.
And both very experienced, very well respected in the field, right?
Yes,
And you wrote a book called Use of Force Investigations, right? This is your book?
it is, yes.
And even in your dedication, you note, to my legal educators on use of force, John Hall, a couple others, Yuri Patrick, and many, many more, I stand on the shoulders of giants. I thank you for your training.
I absolutely do, especially John Hall. I've attended firsthand training programs with John Hall, who's an attorney, former supervisory special agent with the FBI.
And you urge readers over and over throughout your writings on your blog and here to read this book, and the book by Yuri Patrick.
And John Hall, yes, I still do. It's a good book.
And you rely on much of what Mr. Hall and Mr. Patrick say in the field of use of force, right?
In this case, I quoted them in my report, but I wouldn't say I rely on the law first and foremost. As I stated, Mr. Hall was one of my first legal instructors on Graham v. Connor a number of years ago, so I defer to Mr. Hall, who is an attorney, yes.
Who is Mr. Patrick's co-author.
Yes.
Now, let's get back to this case. You said you interviewed a bunch of information. Did you interview the defendant before giving your opinion?
No, I was never given access to the defendant. I did listen to the audio tape of his interview by investigators, as well as read his report.
Okay. You reviewed prior statements that he made, correct? You reviewed a statement, you said a written
To the
statement?
investigators?
Yes.
Yes.
And did you review any statements he made at any other hearings?
Oh, grand jury testimony, yes.
And did you meet with Ms. Stevens and Mr. Collins to discuss the case?
A number of times, yes.
Including this past weekend?
Yesterday, or last evening.
And you would recognize, as you've said in your book, that citizens can be a victim at any time in virtually any place, right? Yes or no?
I'm sorry, which book, ma'am?
All right, let's talk about citizens' armed defense. This is talking about citizens' right to defend themselves, right?
You may. You may continue.
Thank you. You wrote this book, Citizen's Guide to Armed Defense, correct?
I did, yes.
Okay. Talking about a citizen using self-defense, being aware of their surroundings, things like that, correct?
There's a variety of different topics. I have been a firearms instructor and a concealed carry permit instructor in the state of Ohio for a number of years. I also lectured at conferences
Your Honor,
about the...
I hate to cut the witness off, but it's being non-responsive. I simply asked one question.
What was the question, Carlo?
I was asking, oh, I'm sorry.
Talking about a citizen using self-defense, being aware of that is your, being aware of your surroundings, things like that, correct?
He can continue answering. You know where, or do you want to ask another question?
Thank you. And in this book, do you also discuss Graham versus Connor and kind of relate the factors and totality of the circumstances to this situation?
My background is as a law enforcement officer, and Graham v. Connor is about the use of deadly force or use of force for law enforcement officers. Graham v. Connor, Tennessee versus Garner, State v. White do not apply to private citizens in the state of Ohio or throughout the country.
But in your book, and at page 65, you talk about Graham versus Connor factors, the totality of the circumstances, right?
I talk about how these totality of the circumstances and other factors need to be considered by the private citizen using self-defense, et cetera. But once again, Graham v. Connor does not apply to private citizens in this state or any state.
And that's not what I'm saying. You talk about the factors. You explain them to the average citizen, correct?
Could you bring the book?
Certainly. Size, strength, those are the factors I'm talking about. You talk about those Graham factors and others in this book, right?
I say in law enforcement, these components, severity of the crime, et cetera, totality of the circumstances, they need to be considered in law enforcement. However, you know, they also can apply certainly to private citizens, things like distance, time, lighting, et cetera.
Right. So we're just talking about factors that we look at in analyzing the totality of the circumstances, right?
That I use or can be used in those types of private citizen cases, yeah. But once again, Graham, the legal standards for law enforcement don't apply to private citizens.
That's not what I'm talking about. I'm just talking about how you are listing and telling your reader about Graham versus Connor factors.
Or
Agree?
factors to be considered in the use of deadly force in the private citizens, yes.
Very good. And you mention size, gender, strength, right?
Certainly these factors can be considered in private sector as well as law enforcement, yes.
Okay. You don't mention those things in your report, right?
I document.
Skill, I'll give you skill.
I do document Ms. Castleberry's size and weight, but I do talk about the use of an edged weapon or the knife. Once again, and the fact that even the smallest or diminutive person can be a deadly threat with a knife.
And you mention, when discussing gender, that in general, women are easier to victimize, correct?
I don't know if I use the term easier to victimize. There is a strength and size difference, obviously, between men and women, yes.
Women were rated as easier to victimize than men.
Rated by whom, I'm sorry?
I'm reading your book, page 11.
The context, I'm sorry.
Page 11, chapter on Don't Be a Victim. Women are rated as easier to victimize than men. Older persons were rated as easier to victimize than younger ones.
I believe.
Does that sound familiar?
I believe when I talk about rated, this was looking at offenders who were interviewed in prisons and jails about who they would assault, and they said that women were rated easier, as were older people rated easier to assault.
You mention things like environment as a factor that's totality of the circumstances, right?
Yes.
Things like night or day matter, right?
Can matter, yes.
Okay. And you mention time. The ability to create distance is a factor, isn't it?
The fact, or the distance between a subject, an assailant, and the defender is certainly a factor. As I've stated, things at touching distance, especially when we're talking about dealing with the person armed with a knife, are a deadly threat. 50 feet away, that same person may not be a deadly threat. However, we've learned that closer, depending on a suspect running at an officer with a knife, and Mr. Patrick says this in his book, may be a deadly threat out to 30 or 35 feet.
But the ability to create distance is a factor we look at in the totality of the circumstances, right?
Well, in this book, those factors it depends on the circumstances. If it's a surprise assault, you, the defender, you as a member of the jury are out, you're walking down the street, round a corner, and confronted with a sudden deadly threat. The distance is what the distance is. What you do, you maybe offered the opportunity to create distance, maybe not, but that doesn't change your use of deadly force. In other words, just because you could move or create distance doesn't mean that if you don't, it's a bad shooting.
But you can objectively look at the ability to create distance, to have time, to create some space, right?
Once again, it's both ways. It's the assailant, the distance that they are from the victim, their intended victim, and it's also the tactic of, if possible, if time permits, the ability to create distance. But that is oftentimes based on circumstances. What's behind you? If you turn and run, will you be assaulted? In this case, a person with a knife, will you be stabbed in the back if you turn and attempt to run? Same thing with private citizens, which is what this book is about.
Okay. I'm simply asking, it is a factor that you can look at in the totality of the circumstances, right? And assign what weight the reviewer wants to, right?
That's correct.
Very good. And can we agree that when we're looking at the moment force is used, we're looking at the moment the trigger is pulled, the moment of the decision to use force?
Well, that...
Yeah, right? I mean,
I'm answering your question, Counselor.
Overruled. He can answer the question.
Your Honor, the relevance in terms of, is this a question about a private citizen or a police officer?
Okay. To that extent. You can
okay,
clarify.
Very good. I'll clarify. With respect to police officers.
Okay. Could you ask the question again? I'm sorry.
When we talk about the moment force is used, I think you said at the moment force is used. We're talking about at the moment you start to pull the trigger, right? When we're reviewing the decision to use deadly force, the moment of the decision.
The decision is made before the action. That's the way our brains work. We make a decision based on the circumstances. We fire, an electrical signal that makes the trigger finger work. So there is going to be a delay between the decision and the moment the trigger is pulled, but we look at the moment that use of force is applied, yes.
The moment the trigger is pulled.
The moment the decision, yes, based on the decision, right.
All right, let's go to your report. And I believe page 5, I think you already noted, Ms. Castleberry was involved in a previous arrest with no resistance offered by her, correct?
Yeah, very similar circumstances. The police officer...
Excuse me, Your Honor, I just like responsive answers and not narration.
I think your question allows him to respond.
Continue.
Thank you. Very similar circumstances. The police officer identified himself as a police officer and Ms. Castleberry offered no resistance, did not assault the detective. She was taken into custody, etc.
Were you aware she was taken to the library around other officers in that situation?
I believe that was the case, yes.
So it was not exactly like these circumstances, was it?
Very rarely, or do we have the exact same circumstances?
But yet you said it was almost identical. That's what your report says, almost identical, but it was not, was it?
Well, it was a vice detective announcing he was he was a member of the Columbus Division of Police and placing her under arrest. So to that extent, it was pretty identical.
She offered no resistance when she was taken to the library in that instance, around other officers, right?
She chose not to assault the detective or resist arrest. That's correct.
Let's move to, then we have page 6, 7. You have a bunch of photographs of the scene, correct? Or taken from body camera.
Still images taken from Officer McDaniel's body-worn camera, correct?
Right. Then we go to page 10. You mentioned that the prior photo shows the close proximity of Castleberry to the front seat, correct? Do you have your report in front of you?
Yeah, that's addresses the previous photograph, yes.
And you would agree with me that Donna Castleberry couldn't get further away from the front than to go to the rear of that car, correct?
Well, the passenger compartment is as big as it is. She could only move so far within that passenger compartment.
Right.
Yes.
She couldn't get out of the car through the rear doors.
No,
She
my
couldn't-
understanding is that the child-proof locks were engaged.
Page 10, you talk about blood loss making gripping Castleberry difficult. Mr. Mitchell didn't say there was blood all over and he was having a hard time grabbing her, did he?
I don't think he had to. His hand was bleeding. It had been filleted open. It was obvious that there was blood involved in gripping her, attempting to control her.
Well, this information here is made from an inference, not from his statement, right?
No, when you're cut, you bleed. And when you grab with the bleeding hand, blood's going to make it more difficult to grab. That's a fact.
But Mr. Mitchell didn't say blood dripping made it difficult, right?
I'm not aware of that.
Okay. Page 11. Castleberry continued to remain in an agitated state throughout the encounter until the last shot was fired.
Okay, could you refer me to the
Second paragraph, last sentence. We can hear from the audio tape, you say, that Castleberry continued to remain in an agitated state throughout the encounter until the last shot was fired.
Yes, that's correct. We can hear her screaming throughout the encounter.
Do you consider okay, sorry, an agitated state? Is that what you mean by that?
Well, I think that was at the point shortly before she stops, but up until that point she's screaming, so yes.
And you mention, we can see in the surveillance camera video, Castleberry moved throughout the encounter. I'm on the third paragraph, and I'm going to skip a couple words to move this along a little bit. She moves from the center area of the front seat to the passenger window, over the front seat to the rear, and from passenger side to driver's side of the rear seat. So you're saying she moves from the center of the front seat to her passenger window and over the front seat? She's going over her seat?
I'm sorry, she moved over to the passenger window. We know that. She moved over the front seat. There is a front seat and two bucket seats, the center part of the front seat, so that's still a front seat. And from the passenger side of the rear seat towards the center or towards the driver's side of the rear seat. Yes.
Okay, are you saying That is your perspective from viewing the video.
I'm saying that's what happened, and we can see movement that coincides with that.
You weren't there, sir. So where do you get this information?
Well, ma'am, she started in the front seat. We know that. We can see movement on the videotape. She moves from the front seat to the rear seat. We can see that, and we can see that she moves from the passenger side in the rear seat to the center or to the driver's side of the rear seat. That we can see that. And her final rest position was rear seat center or towards the driver's side.
Well, and you started by saying that she was in the center area, in the console area. That's what you're saying you saw in the video.
What she was in the passenger seat. The original knife assault, we don't know specifically where she was, but she had to be within touching distance of the detective in the front passenger seat. She then moves with her back to the dashboard. That would be the center of the front seat area, and then from there, goes over the center area, the front seat into the back seat.
Okay, well, let's talk about the dashboard area. You said she was in the dashboard area. I'm asking you where you get that information.
Well, that was from Detective Mitchell's information that she put her back against the dash area before she shoved her foot into his neck.
Okay. So you're not saying that's what you saw in the video?
It's very hard to see. We can see movement. That movement coincides with what took place in the vehicle based on the evidence.
Does your report ever mention that all the shots were fired from the front to the rear?
Well, that's where Detective Mitchell was. So at that point in time, the shots based on the facts and evidence were fired. I don't know if it was towards the rear. One was upward, so a variety of different angles, but certainly from the front towards the rear. Those are the facts.
Sure. What I'm saying is you don't do any analysis in your report to indicate all the shots came from the front seat to the rear, right?
That was done by the BCI detectives. I didn't do that shooting investigation.
Sure. But isn't that a factor to consider the direction the shots were being fired during this and determining whether it was reasonable or not?
Well, those are the facts. At the point in time when Detective Mitchell fired, Ms. Castleberry was either moving towards the rear seat or in the rear seat. So those are the facts.
Right. And in 25 pages, though, you don't go into any discussion to even say all of the shots were fired from the front seat into the rear seat, right?
Well, ma'am, there's no facts or there's no ballistic evidence that any shots were fired anywhere else.
Right. I'm just asking whether or not you had any discussion of that in your report. And the answer is no, right?
My question was not the location or direction. My question was whether they were within the confines of the law, whether they were objectively reasonable based on the facts and circumstances at the time he fired the shots.
Where the parties were positioned is not important to your analysis?
Oh, certainly. I have never said anything. However, that's the facts and evidence. He fired multiple shots towards the rear of the vehicle where Donna Castleberry was either moving to or in, and several missed and several struck.
Let's move on to the second to last paragraph of page 11. Kind of in the middle. Starts with because of this. Because of this, a reasonable officer in the exact same circumstances inside that car, after being slashed with a knife at the onset, continuing to fight a knife-armed assailant at arm's length, having a suspect then shove her clad foot into the side of his neck to the point of unconsciousness, at the moment the officer fired his 6 shots, would have believed that such a suspect presented a continued risk of death or serious bodily harm to him or herself. You say that, right?
Well, actually, you misquoted me. It's to the point of near unconsciousness, not unconsciousness, so you misstated the report.
Okay.
But yes, I do state
It
that.
actually says to the point of unconsciousness.
No, ma'am, it says to the point of near unconsciousness.
Can I compare reports? I may, Your Honor. Mine says unconsciousness.
No. Where are we at here again? Down here?
Right here.
Near unconsciousness.
Well, that's a different report.
Well, you must.
What is your report dated?
2 June 2020.
So is mine. May I for a moment?
Sure.
Did you edit since last year?
No,
Did
ma'am.
you edit this report in any way since last year?
No, ma'am.
Yes, you may.
We'll continue on, and maybe I'll take a break if you need it. But so yours says to the point of near unconsciousness. Okay. And in that statement, you mention slash with a knife, foot to the neck. You don't mention the door's been opened, right? You don't mention Donna's moved to the back seat in that statement, right?
Well, I'm rendering an opinion about the assault on Detective Mitchell, not about whether he could have run away.
Well, you're talking about what a reasonable officer would have done in the same circumstances, but you left out some circumstances in that sentence, right?
Well, that's because those circumstances didn't exist. He didn't move away. The question is what he did do, was it reasonable? And that's what my opinion is based on.
Well, first of all, you need to believe Mr. Mitchell to believe those circumstances, right?
We have the videotape that shows that Mr. Mitchell did not run away. That did not happen. Therefore, we have to examine what did happen as to its reasonableness.
The door's open. That is a circumstance we objectively know existed, right?
But he didn't run away.
That's not in your analysis here, right?
It didn't happen, ma'am. He did not run away.
No, I'm asking the door opened.
I can concede that the door opened.
But you didn't mention in your report in 25 pages of the analysis that the door was open, right?
He didn't leave the vehicle. It didn't make any difference. It's irrelevant. It didn't happen.
Mr. Davis, the ability to leave the vehicle is important, correct?
Not in this case, Counselor, because we're looking at the use of deadly force, not about what he could have, should have, would have done in terms of tactics.
That's not tactics, according to Mr. Patrick. You aware of that? You read his report.
I disagree. A tactical retreat or moving outside, or what you previously questioned about cover and movement, etc., is irrelevant. Mr. Patrick also states that the tactics, the actions of the officer are irrelevant, Counselor.
Mr. Patrick says that it is not retreat to walk away and contain a subject, right?
But
that's not retreat.
He writes in his book that that's irrelevant, Counselor. That didn't happen. Detective Mitchell did not make the decision to leave the vehicle. That didn't happen. So the question is at the moment that he did fire, was it reasonable based on those circumstances, not on hypothetical of what he might have, could have, should have, would have done?
Well, in fact, the objective evidence indicates the door was open and he stepped out of the vehicle at some point, right?
I believe the door opened, a cell phone fell out, he put a foot down, pivoted back, it appears, what we can see in the video. But that could have been to get a better position, certainly.
That could have been an opportunity to step back and create distance or contain the threat, correct?
But he didn't do that. He didn't have to by law. It's not the set of circumstances in which we look at in this case. It did not happen.
It's not about what he did. It's about what a reasonable police officer would have done, correct?
No, it's about, the question is, in his shoes, what he did at that moment, would a reasonably and prudent, well-trained officer have fired on Donna Castleberry based on the circumstances of being cut, being assaulted by her foot, the fearing that she was going to slit his throat from the backseat? That's the question, not the question of what he coulda, shoulda, woulda done in hypotheticals.
Mr. Davis, I think we all understand that. What I'm saying is we don't have to take his word for it, right?
No, we don't. We have facts and evidence. He didn't leave the car.
We don't have to take his word for everything he says and then say, okay, we accept all that as true, and now we're going to decide if it's reasonable. That's not the analysis, right?
You're talking about a car opening up and a tactical retreat or backing up or whatever. That's not what happened. I can't base my decision or my opinion based on hypotheticals. That's not what happened. He didn't have to legally retreat. He didn't have to legally back up. What he did was reasonable based on the circumstances, on what he actually did based on the facts and evidence.
The facts are he opened the door and he had a foot out, right?
That's a fact.
And you don't discuss that in your report as important at all. Independent facts and evidence.
It didn't make a difference. It's irrelevant whether he put a foot out. The question is whether the shooting was within the law.
And the totality of the circumstances that existed when he fired.
Irrelevant of his actions, yes. Irrelevant of his tactics, yes. As your own expert has talked about.
You didn't hear Mr. Patrick testify, did you?
No.
So if Mr. Patrick said that's not tactics and that's relevant to the totality, you just think he's wrong?
No, I think it's in conflict with what he's written and he and Mr. Hall have talked about. And I find that it's not in keeping with Graham v. Connor and it's not in keeping with State v. White. They don't, neither Graham v. Connor nor State v. White talk about police tactics. You know, what they talk about is reasonableness at the moment that force is used.
And State v. White is the very case Mr. Patrick testified in, right?
Yes, in which he said that an officer need not be positive.
Yeah.
The question was, that's the case in which he testified.
Yes.
Thank you. Let's go to page 12, the severity of the crime at issue. Do you at least recognize that Mr. Patrick says when we look at the severity of the crime at issue, he says you're talking about the soliciting charge? Correct? You're aware he says that, correct?
I was asked a question about the severity of the crime at issue. I'm not aware of his testimony.
You read his report, right?
Yes.
You mentioned on page 12, and I am in, assuming these match up, the large paragraph kind of in the middle, starts with she was shot.
Yes, ma'am.
I'm going towards the middle. The entire time of the encounter within the close confines of the vehicle, Donald Castleberry continually presented a deadly threat to Detective Mitchell. She could have chosen to drop the knife, not physically attack the officer, et cetera, et cetera.
Yes.
Okay. You said, oh, I'm sorry, and then I need to go on the next sentence. She could have put her hands up and literally surrendered. Correct?
To the officer's lawful authority, correct?
Correct. So in order to know what a suspect is doing, you need to look at them and see if they're putting their hands up, right?
Well, that's the totality of the circumstances, certainly.
And you said she continually presented a deadly threat to Detective Mitchell. And you base that on the fact that they're in these small confines, that she's still a threat in the back seat. Is that what you're saying?
Well, we know that she had cut the detective. We know that she had a knife. We don't know at what point that she dropped the knife, threw the knife. We simply don't know. It was his reasonable fear that she was a deadly threat when she was behind him, and certainly we can understand that a suspect to our rear with a knife is more of a threat than a suspect in front of us.
Well, Mr. Davis, if he steps out of the car and pivots and he's looking her way, she's no longer behind him, right?
At that point, then he's facing her. That's correct.
Okay. So this isn't somebody continually behind him throughout the encounter, right?
No, but the decision to shoot was when she was to his rear, and his statement is that he was afraid she was going to slit his throat.
And the circumstances then changed because the door opened, he stepped out, he was able to get out of his seatbelt and turn, right?
He moved to in position, yes.
Page 13. You routinely talk about, I'm sorry, I'll try to find the right reference. You've called it here today an attack by Donna. This was an attack by Donna Castleberry.
I'm sorry.
Throughout the encounter?
Yeah, can you tell what page you're on?
Yeah, well, I was referring to prior testimony too, that he was attacking her throughout. So I'll go to the first, we'll start with the...
I'm sorry, Counselor, you said he was attacking her throughout.
I'm sorry, she was attacking him throughout, you've stated. Okay. Second paragraph, attacking the law enforcement officer. I'm just, in general, you refer to this in your report, right, as an attack on the officer or a felonious assault on the officer, right?
Yes, she drew a knife, opened it up, and feloniously assaulted the detective. She then shoved her foot in the side of his neck. That's a felonious assault.
And she was committing this attack while saying, help, get off of me, according to the objective evidence. Is that what you're saying?
That was recorded on the audio, yes.
Okay. And open the back door, help me please, during the attack. Those were her words.
Yes.
Okay. You say it would, on page 13 again, I'll try to find the exact, 1, 2, 3rd paragraph, second sentence, it would be strictly hindsight-based supposition to propose that Castleberry was unarmed or no longer a deadly threat at some point in the armed encounter because no physical evidence indicates so and there is no way to prove that A, when she dropped or discarded the knife, and B, that Detective Mitchell knew she was unarmed.
Correct.
Okay. And would you agree we have a knife found on the front seat, correct?
Well, a knife was photographed. I don't know where the knife was found. It was not photographed in place. It was placed point up against the driver's seat and photographed there. But based on body-worn camera, that's not where it was after the shooting.
Based on the body-worn camera, what are you saying?
Yes, ma'am. I reviewed Officer McDaniel's body-worn camera, and there are still images. The knife is not in that position when it was at the encounter. It had been placed there for photographic purposes.
When it was on the seat of the car?
Point up on the driver's seat.
You're saying someone moved the knife?
I'm saying that, yes, it was not photographed in place, and it was placed there.
It was found on the front seat, the driver's seat, right?
Somewhere, Counselor. It wasn't photographed in place, is my understanding. You can't see it in that position on Officer McDaniel's body-worn camera or still images created from that.
When an officer is making a decision to use deadly force, preparing to pull the trigger, he needs to assess the threat, right?
Well, that's part of what they do. Is we're primarily site-based creatures, so we're going to look to see, and of course, in this case, the assault happened before he knew there was a knife present. He had been cut before he knew that she had a knife on her. So the assessment was made based on his wound.
Before you pull the trigger, you should look at the suspect, see what they're doing, and see if they're a threat at that moment, right?
To the greatest degree possible.
Thank you. Officers are trained to focus on the threat, right? The knife, the gun, cell phone, whatever the object may be, correct?
No, they're trained to focus on a center of mass and on their sights, not on the weapon system.
Well, before you decide to shoot, when you should shoot center mass. But before that, you have to determine if the threat exists, right?
That threat had already been substantiated based on the cut.
Mr. Davis, a cut 45 seconds earlier does not categorically allow an officer to use force 45 seconds later, right?
But it was testimony from, or statements from Detective Mitchell that at the point in time when he diverted his attention, he let go of her arms, she still had the knife. When she moved past him, she still had the knife. So it wasn't 45 seconds.
Well, you just said the cut on the hand. So what I'm trying to establish is before an officer pulls the trigger, just in general, before an officer pulls the trigger, he looks at the threat, he assesses the threat, he's focused in on the object that's the threat. That's the training, right?
No. And when I say no, what I mean by that is that we're talking about the decision to shoot, which is a time delay. We know that Donna Castleberry had a knife. We know that she feloniously assaulted the detective. The decision to shoot was made when he let go of the hands when she still had the knife. He then had to access the handgun, and at that point, as she's moving next to him, his statements are she still had the knife. At that point, the decision to shoot had been made, and his first shots, from what I understand, his statements are shot across his chest to fend her off. It's very hard to see someone to your rear and to see the whole person under those circumstances. Once he pivots, the handgun is up, and that's going to block his view of her body, her hands. Also, she's kicking, from what I understand, and moving.
First of all, this is assuming you believe what Mr. Mitchell says, right?
Well, once again,
you just recited what he says, right?
To coincide with the video and the facts and evidence, ma'am, we know that she moved from front seat to rear. We know she had a knife. We know she moved from the rear passenger seat towards the center or the driver's side. All those things are facts and evidence.
We know the door was open.
We know that he opened the door.
And an officer is trained to watch a suspect's hands, especially if he knew that's where the threat just was, right?
Well, at some point, he has to divert his attention. He can't watch her and get his gun and make it ready to be able to shoot. He has to divert his, especially with the handgun at the side of the seat. That's going to not be what we call a motor program, or what you call a skill that he has practiced. So he's going to have to be more attentive to getting the gun than her. And his statements are that he feared that she would slit his throat from the rear seat.
You are again relying on his statements. I'm asking about basic officer training, okay? Officers are trained to focus on the hands. If there was just a knife in a hand and you're in a training scenario, you focus on that hand, right?
We train officers to focus on hands prior to incidents. We don't want them to wait until a suspect has a knife in hand. It's to watch their hands, because what's in their hands can kill them. But in this case, what was unknown in Donna Castleberry's hands was used against the detective.
So in your analysis, the fact that he didn't know what was in her hands makes her a deadly threat throughout because he didn't know.
What he did know is that she had a knife. What he didn't know was where the knife was at the time that he fired the shots. That's the statements. Those are the
So
statements.
what could Donna Castleberry do?
Submit to the lawful arrest.
What could she do when she was in the back seat?
Submit, counselor.
What does that look like?
In my case, anything is, I stop. Okay, I'm done.
Okay.
Yes, with hands up, submitting to the lawful arrest. No longer kicking, no longer moving, stopping and submitting.
No longer moving, just freezing?
Yes, submitting.
Moving away?
She couldn't move any further away. She was in the back seat.
Exactly. Page 14, can we at least agree, you've got a timeline, that it was 45 seconds after he said he was cut, approximately, that he fired the weapon? Agree with that?
From when he says he's been cut until the first shot?
Yes. About 45 seconds? Does that sound right?
That's somewhere in that nature. I understand that Agent Loomis's timeline is different. I submit to his expertise, but my report indicates those times.
When Donna went from the front to the back seat of the vehicle, tell me objectively, what did you see or hear to show that there was a deadly attack at that time?
What did I see or hear? Well, the attack was ongoing. She was moving. We don't know when she dropped or threw the knife. We simply do not know. There is no evidence that she dropped the knife at any point prior to the last round being fired.
Mr. Davis, you say these actions, until her actions, I'm sorry, page 14, second to the last paragraph, her actions were finally de-escalated by way of police gunfire.
I'm sorry, second to last paragraph?
Yes. De-escalated by way of police gunfire. That's de-escalation.
Yeah, yes. Yes. De-escalation means that she was no longer a threat. There is no definition of what de-escalation means in law enforcement. It can be everything from talking to somebody and trying to dissuade her or dissuade them. In this case, at the beginning stages, he used de-escalation tactics to try to keep things calm. But once she feloniously assaulted him, once she created a deadly set of circumstances in the vehicle, the de-escalation was the gunfire. She was stopped at that point.
And I'll get to de-escalation here in a minute, but words and talking, those things are relevant in these determinations, aren't they? What people are saying, it matters. It may not carry the day, but it matters.
Not to override their actions. We have to look at their actions. Many times suspects say things that are not in keeping with their actions to try to lower an officer's readiness. For instance, okay, I'll comply or whatever, waiting for the point to assault the officer. So we have to look at words and compare them to actions.
So in comparing words, you know what, I'll strike that, I'll move on. Page 14, very top, you call Donna an armed, committed, determined, violent attacker.
I'm sorry, Counselor, you're saying page 14?
I'm sorry, am I on 14 or 15? No, I am on 14. I'm sorry, the very last paragraph. Indeed, Donald Castleberry was an armed, committed, determined, violent attacker.
Yes, I believe that's true, yes.
Page 15, you talk about there was no reason to retreat. There was no legal or tactical reason for Detective Mitchell to run away, but rather compelling reasons that this determined, armed, violent female attacker needed to be stopped. That's what you said, right?
I don't believe I used the term run away. I said that earlier, but I used the terms retreat or escape.
Okay, maybe that's another difference. We have Detective Mitchell to run away, yours says retreat.
I'm sorry, I don't know where you're at, Counselor.
Approach, I'll just compare with you. Right above use of force. There's Mike on a different page then. Mortal wound, ocean.
So legal or tactical, that's...
Yours is different. Well, you said run away, retreat, we'll go with that.
No, I didn't say run away. I said run away, but I didn't write that in my report. No, I said retreat or escape.
So we're not talking about somebody running away from a school shooting or running away from a bank robbery, right? We've got a confined attacker who can be trapped and contained, right?
Well, in your analogy, we train officers to move to the sound of gunfire. That's what we pay officers to do. We don't pay officers to run away.
Sure. But where there's an opportunity to escape and a dangerous attacker who's in a vehicle with a knife and you can contain that, you don't run to that danger. That person can't go anywhere, right?
That's what we pay officers to do, ma'am. They're law enforcement officers. We pay them to enforce the law. We don't pay them to run away and have Miss Castleberry present a deadly threat to someone else in the parking lot or what have you. We don't pay officers to do that. We pay them to enforce the law.
Miss Castleberry couldn't get out of that car and he knew it, right?
Well, he knew it because he was blocking the exit and she could not get out because he was trying to take her into custody and she presented a deadly threat.
She's not a danger to anyone else in that parking lot, right? That's not.
No, not at that time, no. No, but you brought up the thing about running away.
You're calling it officers have a duty to approach and to go towards the threat. But that's not this situation. This is not like a school shooting, go to the threat, right?
But he's in this situation. We didn't pay Detective Mitchell or the citizens of Columbus pay Detective Mitchell to run away. That's not his job.
We train officers to preserve life when possible, right?
Preserve their own life as well, yes.
And citizens. We train them to make distance, to take time and cover when possible, right?
But it's not a requirement by law. It may be a tactical suggestion, but based on the circumstances, we didn't have that here. We know that Detective Mitchell did not run away. That's not a factor in this shooting.
We know that the door was open and he had an ability and did in fact step at least a foot out of that car, right?
We know that the door opened and he stepped a foot out, yes.
In your armed defense book, you talk about if an officer feels a risk is too great, back up to a position of cover and hunker down. In this way, you can set up an ambush. Those are concepts that are trained, right?
I'm sorry, ma'am. You're holding a use of force investigations book and you're talking about another book. I'm not sure what context you're asking the question.
Your book, Use of Force Investigations, specifically talks about law enforcement investigations, right?
Yes, but you referred to the Citizens Guide. You referred to the different
I'm sorry.
book.
I apologize.
So
Let me get my quote proper here. Page, yeah, maybe I am on the wrong one. Give me just a moment. 43. Okay, you're talking, the chapter, it appears, on 139, you start with active searching and response, talking about conducting what police call a slow and methodical search takes time. Then you go into a case study and continue on and to talk about challenging intruders. You give some examples throughout this book, right, about what police do. Would you agree with that?
I'll take your word for it, Counselor.
Okay, thank you. And you indicate that police officers will make all possible haste towards a burglary in progress armed homeowner call, a robbery or shooting. But when you're the one involved and forced to wait, it can seem like hours. You want to call or have someone else call prior to contact, if at all possible, and when safe to do so. If the threat is imminent, call police. And you go on talking about attack scenarios and time and distance and things of that nature. Do you recall that?
This is about a homeowner burglary where you're the homeowner and a burglar or home invader has entered your home. This is not about police officers, once again.
But the concepts you discuss often overlap between what is a reasonable use of force and what a citizen may look at in considering their use of force, right? There's some analogies to be made here.
In this context, the recommendation would be that the homeowner not engage in going out and searching, that they, what's called an ensconce, or that they take a position with their firearm and that they call the police and let the police do their job. And the police are not going to stand back and wait unless it's a barricaded subject type of call where the person has a gun, they don't make entrance. But normally the police are going to search. We don't want the homeowner to do that. So the analogy between that and this case is just not there.
Okay.
Does council want to approach?
When I was going through it, and if I'm wrong, I'm happy to let someone correct me, but I couldn't find a reason it was in here. On page 8, it says the test of reasonableness, an objective one, and I think we just need to clarify, I don't think it's necessarily wrong, but the focus is specifically on the moment he used his weapon. Then it says, and in the moment's directed proceedings. So, I don't know if we really intended to say, I think the focus is specifically on the moment he used his weapon.
What part of the, on page 8?
Page 8 at the top,
Okay,
assuming we all have the same exact one.
I have mine.
Okay, yeah. The focus specifically on the moment he used his weapon, and it says, and in the moment strictly proceeding. I don't want to make it confusing and make the jury think that they're considering the reasonableness of the firing, the decision point, at any moment prior. So I thought maybe if we put the words, focuses specifically on the moment he used his weapon and considering the circumstances in the moment's directed proceeding.
I think it's fine just the way it is, Your Honor. I mean, both experts have testified that there's a decision to make to use deadly force. There's a process, and then weapons fired. I mean, I think that says that there, right?
No. The moment he used his weapon is what we're looking at, not in the moment's directed proceeding, which is unclear and implies that we.
Well, didn't both experts say?
They said at the time you pulled the trigger.
Before.
I'm sorry?
Both experts said he had to have made the decision, and then he goes through the mental process to go get the weapon. Then but.
Right, but the focus isn't on the decision point. That could be 20 seconds earlier in the case. It could be 2 minutes earlier. The point was when you actually employed it anymore. So it's super clear with Mr. Patrick to make sure that that's where we were with that. That's the problem I have with that.
Let's wait till we can find that out here.
I believe
Okay. I think Mr. Patrick said, before he could use it, he should have shot her after she cut him.
Right, but then when you talk about.
Isn't that preceding the firing of the weapon?
I'm sorry?
Isn't that preceding the firing of the weapon?
Yeah, and I'm just asking to clarify that what it says the focus is specifically on the moment. As long as we're talking about We're not talking about the moment of decision. As long as we clarify the moment of decision as a separate point, that's what I'm concerned about. That's why I think it's a little bit confusing here.
I'm going to keep the same jury instructions we used last time, other than that minor change on mine. So you can go print them up. Do we need to put anything else on the record prior to, anything on behalf of the state? Go get jury. We'll get you out of here sometime. Did you drive back to Akron?
Yes, this afternoon. Drive down was stormy.
Oh, what?
Oh, yes.
We didn't get much rain down here.
No, it was raining around Mansfield quite hard.
My mother is from Youngstown, so when I was a kid growing up, we would always drive to Akron back when they had the Firestone.
Oh, yes.
You could smell that when you get on 77.
Back in the day, all my uncles were tire builders.
Okay.
What's the second question you asked?
I knew we were getting close to Akron.
Here, I'm going back to where I was.
And that's back in the 70s.
Mm-hmm.
60s and 70s.
Oh, yeah.
All rise.
You we get that seat? So during the break, Carla said my social experiment's going awry, that you guys are switching seats now. I didn't notice that. Mr. Davis, you're still under oath.
Thank you, Your Honor.
Any further cross?
Yes, thank you, Your Honor. Mr. Davis, I think we were on page 15 when we left off, and I want to ask you about the last sentence at the top of the page. Had Detective Mitchell not fired on Donna Castleberry and stopped her, innocent civilians in close proximity might be at risk.
Correct.
You wrote that.
I did.
We've established Donna Castleberry was not getting out of that car, right?
Well, had she inflicted a mortal wound or Detective Mitchell moved off and allowed her to escape, the potential was there. We don't know what she would have done.
Do you take into account inconsistencies in the evidence in coming to your opinions?
Inconsistencies, ma'am, I'm not sure what you mean.
If you find inconsistencies, if you find varying statements by witnesses, by the officer, do you take that into account when you write your opinion, your conclusion here?
I do, depending on the who the witness is, proximity to the event, etc., time. If the officer involved has made conflicting statements, does that comport with the evidence? Yes.
Okay, and then so when there's conflict like that, do you put that in your report, or do you become the decision maker as to what position to take?
Well, it's my opinion based on my review of the evidence. So it's my opinion. I'm the arbiter of what goes into my opinion.
So when there's conflict, you'll choose what you believe and form your opinion from there, correct?
I form an opinion based on my review of the facts and evidence.
You mentioned at the, I think it's the bottom of yours, it might be a little bit different, the paragraph that starts, a threat is a capability to do harm. Do you see that?
That is the last
A
paragraph.
threat is a capability to do harm joined by hostile intent. We use a lot of things to determine someone's intent, don't we?
That is a quote from Thomas Petrowski in that published article in the FBI Bulletin. I quote him, but yes.
We use actions, right?
Yes.
To determine intent. We use words, right?
Depending, but yes. As I said before, balanced with the actions.
Sure. Let's move to page 18. And underneath the photograph of the knife, unable to control Castleberry using verbal de-escalation, Detective Mitchell attempted to grab and control, which only led to a serious injury by way of cutting. You see that sentence?
I do, yes.
Do you consider, fuck you, I'm going to have to handcuff you, de-escalation?
I consider it frustration on the part of the detective. Unfortunately, we would like all police officers all the time to not use profanity and not curse, but, you know, I'm not going to tell you that that doesn't happen. As a former chief of police of mine said, it's the language of the street, and sometimes it comes out.
The language shows frustration, anger, things like that, right?
Well, the anger is a subjective emotion. Isn't relevant to the use of force. So examining or saying it was said in anger is irrelevant.
You recognize officers should try to de-escalate, right?
I'm sorry, ma'am?
You recognize officers should try de-escalation, right?
Depending on the circumstances, not all. I mean, the suspect dictates their circumstances, and the officers can't de-escalate a actively attacking or resisting subject.
You talk about it being a sound strategy to slow things down for an officer, right?
If at all possible, but once again, the suspect acts, the officer responds. So not all the time can we slow things down. If someone's shooting at you or stabbing you, you can't talk to them out of that or talk them out of that.
But when you're trying to handcuff somebody, you can attempt to slow things down and de-escalate, right?
I think Detective Mitchell did that up to a certain point, and then she was calling out to an occupant of the apartment, and he was attempting to establish control. So at that point, attempting to handcuff was a reasonable thing for him to do.
Calling out to a bystander to call police, you're saying, is what caused the escalation?
I'm saying that her behavior began to escalate at that point. He had already identified himself as a police officer. He had already texted back up, and said, I'm calling my buddy or whatever. He had attempted to slow things down at that point, but it was Miss Castleberry that escalated her behavior at that point.
So you're calling, they paused and sat there calmly for a while, right? Until the guy walked by and she yelled out. Would you agree with that?
Until she moved over and began yelling at him, correct.
Until she moved over where?
I think to the window area and called to him. I mean, there was movement.
Leaned in her seat, you're saying? You're not saying she moved within the car?
No. Well, she moved towards the window, I would say.
Inferring that, right? That's
Inferring what? Inferring what, ma'am? I'm sorry?
That's an inference that she had to move over to do that, right?
Well, she called to him, so I guess that's an inference.
I mean, I guess you're inferring when the window went down, she leaned out or something.
Or she was seen moving in the seat.
Okay. So she calls out to him, and he hasn't handcuffed her yet, right?
No, not at that point.
There was a period of time. It was only when she said, they're showing your picture, you're out here kidnapping, something to that effect, that he says, fuck you, I'm going to have to handcuff you, right?
At some point he says, after her comments, fuck you, I'm going to have to handcuff you.
And page 18, you talk about the movement in the seat. What is your understanding
I'm sorry, can you direct me to which paragraph?
Just in general, the second full paragraph underneath the knife photo, screaming, kicking.
Okay.
Just in general, you're talking about the position. She was in the front seat, right? And then the second paragraph, you talk about his position. So I'm just talking in general about the positions of the parties.
Yes, both started out in the front seat, he behind the wheel in the driver's seat, and she in the passenger seat, yes.
Okay. So what is your understanding of where he was behind the wheel in the driver's seat? During the struggle, what's your understanding of his position?
During the entire encounter, or at what point?
Let's start from the point after the cut when he indicates there was a struggle.
Well,
What is your understanding that you relied upon in your report of where he was positioned?
he had to be positioned after he was cut to grab her arm, so within touching distance of, either leaning in or where, depending on her position, but within touching distance or holding distance of her arms.
Okay, so he was sitting in his seat, you're saying,
Yes.
right?
Yes,
And
apparently.
you had mentioned that she was in some sort of position on the console, on the dash, I think you called it?
I think the movement described as put her back against the dash or the center of the dash and then pressed her foot on the side of his neck.
Okay, and your understanding of his positioning during that, what do you believe his physical position to have been when she had her foot on his neck?
Holding on to her arms, seatbelted in his seat with her foot against his neck.
Okay, very good. And that is based upon his statement, correct?
And the facts and evidence, there was DNA recovered from the bottom of one of her shoes.
Let's talk about that for a minute. DNA, as you know, can come from an arm, a hand, a leg, face, a neck, right? Various parts. And there's transfer DNA, right?
I'm not a DNA expert, but all I can state is that DNA evidence was found on the bottom of her shoe consistent with pressing her foot against his neck.
Also consistent with her kicking at him, right?
I would assume that if she kicked him, made physical contact, that could be possible, yes.
Also consistent with being in a vehicle that was exclusively his and moving around in that vehicle, right?
That part I defer to experts. I'll stay in my lane on that, Counselor.
Okay, then with regard to saying there's evidence on her foot, you can't attribute that to it being from his neck.
I can say it's consistent with his statement and testimony.
It is consistent with a lot of other possibilities as well. Agree?
Once again, I'll stay in my lane. I'm not a DNA
Okay.
expert.
In your report, you said he was trapped against his headrest. I'm sorry, not in your report. You said it just here a few moments ago, that he was in his seat belted in, and you kind of made a motion like the head against the headrest, right?
Well, pressure was being exerted by Miss Castleberry with her foot against his neck while he's holding her arms. That's once again described by the defendant.
And do you explicitly describe that position in your report somewhere, or just that he was seatbelted in his seat with a foot on his neck? Do you ever classify him as trapped in his seat? Let's put it that way.
I can't recall, Counselor, whether he was, I use the term trapped.
And if the evidence would suggest he wasn't, in fact, in his seat, would that change your opinion?
I haven't seen any evidence to the contrary, so a hypothetical, I'm not sure how to answer that question.
Well, if you're wrong on an underlying basis or fact that made up your analysis, it was part of your opinion, that has to change the analysis, right? It has to factor into the analysis if you relied on something and then it turns out to be something different. Agree?
I've not heard any evidence contrary, but I haven't listened to Detective Mitchell's testimony.
Exactly. If there were evidence contrary, it could affect what you've relied on as the basis for your opinion, right?
Certainly if things change based on the facts and evidence.
Two. I'm sorry, gotta get to the right page here. Our pages are a little bit different. page 19, I think it's going to be. There's a mention of the shots. How many shots were fired, how long it took. Are we on the same page here? There's not a title to it, so I don't.
Yes, I see that on page 19.
Okay. And I think you have an elapsed time of about 14 seconds for the 6 shots, right?
That's my conclusion. I understand that Agent Loomis said it was less time, but that was my conclusion.
Okay, Agent Loomis?
I believe that's the video expert that examined the video.
Okay. You're saying he made a determination of the timeline involved here?
That what I did was work on the video and the audio, but I acknowledged Agent Loomis's expertise, and that timeline was reported by your previous expert, Jamie Borden, as 12 seconds, and I believe Mr. Patrick is 11 seconds, so I will submit
13.
13?
So we're going to say a range of 12 to 14 seconds. Fair?
Fair.
Mm-hmm. Great. So 6 shots over the course of approximately 12 to 14 seconds, right?
Correct.
You personally have fired 6 shots in 1.17 seconds, right?
I actually...
Have you?
I've shot faster than that, Counselor.
Okay. So an officer can fire off 6 shots in a well-trained officer in a second or fractions or maybe less, according to you, I guess, right?
Well, experts can fire 6 shots in less than a second. But once again, that's different standards. My tests that I've done was, once again, friendly aligned to a target, drawing from the holster, or with the pistol out, just timing the time it takes me to cycle the trigger. That's a little bit different than this circumstances where you're firing across your chest, you're moving, you're firing one-handed, and then you change hands and fire with the opposite hand. So all that's going to factor in with time. So that's apples and oranges. You can't compare an average, or when we look at the amount of time it takes for an officer to fire 6 seconds or the potential, we have to examine the totality of the circumstances. In other words, what was the officer doing? Was he wounded? Was he exhausted? How close was the target? Was the target moving? All these things factor into the cadence of fire. And here we have a completely different set of circumstances, one that I've never dealt with before.
You're aware that officers firing to save their lives fire rapidly, right?
There is no stopwatch or tape measure at any officer-involved shooting. Every single one is different. To say that they fire quickly belies the fact that we have to examine the circumstances. And in these circumstances, it involved, awkward shooting, movement, change of hands, all those things factor in to the cadence of fire.
Mr. Davis, you're aware that Mr. Patrick found this cadence very unusual, of more than 150 cases that he's testified in, right?
Overruled.
I don't know what Mr. Patrick has found. I don't know whether he's ever dealt with a shooting of this type in a vehicle.
Don't talk over each other.
Sorry, Your Honor, I'm just looking for more direct answers.
Carla will yell at me.
Thank you. That I don't know if Mr. Patrick has ever examined this type of shooting by a plainclothes detective in an unmarked vehicle under these circumstances. I would be highly skeptical, that he had another shooting of this type.
Well, you haven't had one of these either, right?
That's true. As I stated, it's an anomaly.
Mr. Patrick has many, many years of experience being involved in reviewing police-involved shootings, right?
Objection, Your Honor.
Overruled.
I don't doubt Mr. Patrick's expertise or experience. I understand it was about 30-some years with the FBI. Myself, I was involved in law enforcement for 39 years.
and officers must account for each bullet they fire, right? You'd agree with that?
As I stated before, officers are inherently inaccurate in their shooting, and oftentimes tragedy happens where an errant round causes an inadvertent, unintended injury. So officers are accountable for them, but understanding that they are inherently inaccurate in these types of situations explains that they sometimes miss and sometimes hit innocent bystanders, hostages, a variety of things.
Okay, but they have to account for each bullet they fire. They have to have a reasonable belief they're in danger for each bullet they fire, recognizing it can take time to stop firing. Fair?
Well, they make the decision to shoot. There's an on switch where they make the conscious decision to shoot. They perceive the deadly threat, and then there's an off switch, which is they perceive that the threat is no longer in existence. During that period of time, they can shoot a number of rounds. In this case, it was not that many, comparatively speaking. It was only 6. But officers in these types of situations or in shootings with this type of timeline could frequently empty their entire pistol.
In just 2 to 3 seconds, right?
Well, during that, certainly within the amount of time we're talking about here.
And officers are not trained to shoot until their gun goes dry or till it's empty, right?
No, we see back in the revolver days when there were 6 shots, 5 or 6 shots, that officers frequently shot their revolvers empty, and we see that a lot now with modern semi-auto pistols, that officers perceiving a deadly threat continue to shoot, and oftentimes shoot to what's called slide lockback, or when the pistol is empty. The question is when they made the decision to shoot, based on the totality of the circumstances and their perceptions, was there a deadly threat?
So the training is not shoot to empty your gun unless the circumstances would warrant that, right?
That's correct.
Okay. And you've reviewed the statements in this case, right?
Statements
You
by...
have a file. You had the investigative packet, right?
I do, yes.
And are you aware of a statement by Mr. Mitchell that he fired until the gun went dry?
Well, I know that Detective Mitchell's pistol suffered a failure to extract, that an empty casing was not completely ejected from the ejection port. The gun at that point in time was what we call a malfunction, and he could pull the trigger a lot more times. It would never go off until he cleared the malfunction.
But that wasn't my question. Are you aware of a statement that he was taught to keep firing until the weapon goes dry?
He was taught that? I'm not aware of that.
Page 22, at least it's my 22. I think it's, let me skip over. Page 20 should be some quotes, sympathetic nervous system, and quotes by various authors, right?
Correct.
And then 21, you have additional quotes by an author about ATP and some other energy systems, right?
ATP-PC, which is in these types of incidents, the word is...
I didn't ask. I wasn't asking a question. Is that what you're
Okay.
talking about in these pages? I'm just trying to get to the proper page. You're not an expert on those areas.
Oh, I am, ma'am, yes.
Okay, just not DNA.
Well,
You're an expert on these
amongst other
areas?
things, I'm not an expert, but if you're asking if I'm an expert about energy systems in these types of situations, I am.
Okay. Page 22, again, a bunch of quotes, various case law, right? And then and page 23, several quotes by Mr. Patrick. Is that what your document looks like? I'm trying to get us to the right.
23. Well, I believe one quote by Mr. Hall and Mr. Patrick, yes.
Okay, I need to figure out where your 22 and 23 begin then.
That's one approach.
I'll just look at you. If you could just give me a second, we're going to try to clean this up. Yeah, I'm good now. Everything else is on. Okay, I think we're matching up now. You discussed, and we've discussed here, tactical retreat. Just generally, we've talked about tactical retreat.
Yes.
And you've described backing up, making distance, creating space as a tactic, right?
That's correct.
Okay. And said that that doesn't have any relevance here, in your opinion, right?
Well, in my opinion, but also in your experts' previous writings, that it's irrelevant.
Well, we've established we disagree, Mr. Patrick, and you disagree on that point currently, correct?
Well, reasonable minds can disagree.
And while information about how Mr. Mitchell did his job that day, whether he had backup, things like that, are not relevant to the reasonableness of the shooting, right? We on the same page so far?
Yes, to the application of use of deadly force, whether he was alone or backup was there is irrelevant.
It's irrelevant to the reasonableness of the use of force, but it's not irrelevant to his credibility, right?
Whether he backed, I'm not sure I follow the line of question.
Those matters discussing how he performed his job go to his credibility and whether he's a well-trained officer, right?
I don't think credibility can be inferred by tactics. There are so many wide variety of tactics, and tactics are so subjective in nature. One officer may move forward, officer may move to the side. You can't say that credibility lacks because of the tactic they used.
It's a general factor that one could consider in a criminal case, credibility, right?
Well, the question is, would a reasonably prudent and well-trained officer in those exact same circumstances have used deadly force at the moment that Detective Mitchell did? Not whether, in light of hindsight, based on Monday morning, we can find that they could have, would have, should have done something else. That's not the question. That's the law under Graham v. Connor, the law under State v. White.
And we don't just take the officer's word for it. So it's...
This is thing.
If Officer Mitchell had said, Donald Castleberry pulled a gun out of her dress and fired at me 2 times, so I shot her, in light of this evidence, you wouldn't just take his word for that, right?
Well, no, we'd have to have the gun and the gunshots. I mean, the fact is that Donald Castleberry had a knife. She opened it up. She cut the detective. She put her foot against his neck and pressed. She moved erratically. She moved to behind him. It made him fear that his knife was, or his throat was going to be slit. All that is what we factor.
And if we have facts that the objective evidence does not support, we don't just take the officer's word for it,
Objection,
right?
Your Honor, ask and answer.
Well,
That's different there, as opposed to, I think that was a general
that's a
question.
yes or a no.
I'm sorry, ma'am. Can you ask the question again? I was distracted.
If the objective facts are different than what the officer said, we don't just have to take his word for it, correct? Yes or no?
No, we examine the facts, certainly.
It's an objective, independent review. Just because he said it doesn't mean we have to take that as gospel in our analysis, correct?
Objection, Your Honor.
Ask and answer, sustain.
It wasn't answered. Page 24. You should have conclusions. There's a few more quotes, a couple more cases, Mr. Patrick's quote, and then Section 12, conclusions and opinions. You with me?
I'm in the general area, Counselor. Go ahead and ask your question.
Heading conclusions and opinions. Second paragraph, on 8 August 2018, it was August 23rd, right? Not the 8th.
That is a typo.
Okay. I think that appears twice. Your cover page as well.
I'll take your word for it. Yes, it's wrong.
You discuss on, I guess, 1, 2, 3, 4th paragraph under conclusions and opinion that Donald Castleberry committed the elements of soliciting, and one that she knew would normally lead to a summons and release unless she had a warrant. You're talking about what Donna knew right there, aren't you?
Based on our previous experience, which we have evidence of, yes.
You're making an inference of what was in Donna's mind and what Donna knew based upon the fact that there was a prior arrest, right?
Well, yes, we have evidence that there was a prior arrest, and she had that experience.
Okay. So you're talking about what Donna knew. Does that factor in this analysis?
Insofar as we can state that her experience, we can document her experience, but other than that, it has no relevance as to what she did when she feloniously assaulted the detective in this case.
So if we can use it to document her experience, if her experience was officers generally take me to the library where there's a bunch of officers around when they arrest me, we can consider that too?
That was her previous experience. I'll concede that.
So do we consider it or not?
Well, my understanding is that the vice detectives took them to different places, not just one location. They took them to different places based on which side of town they were working. So in that previous incident, it was to the library. I'm not familiar with Columbus, but let's say it was from Yale Street. The library would have been that location. That's fine.
So you don't know what Donna knew that day, right?
I can only read her manifested intent based on her actions.
Well, might her manifested intent and actions been she was scared she was about to get kidnapped?
Objection, Your Honor.
Sustain.
Is a logical interpretation of her statement, help me, I know who you are, they're showing a picture. You've been out here kidnapping women.
Objection, Your Honor.
Overruled. Let her finish the question.
I think under these circumstances, especially when we just talked about her experience, that her experience was that she was placed under arrest for the crime of soliciting prior in very similar circumstances. We talked about that earlier. If she had submitted to that lawful arrest, she would have been placed in custody based on her warrants, but that would have been it. She's the one that chose to escalate that simple arrest of soliciting into a felonious assault and created the deadly set of circumstances which led to her demise. Ms. Castleberry did that, not the detective.
Mr. Davis, you put in your report what she knew. There's another interpretation for that, correct?
What she knew when she was arrested prior?
You said she knew this would normally lead to a summons and a release if she didn't have a warrant. So you're talking about what she knew. There's more than one interpretation for what was going on in her mind. Agreed?
I can't read her mind. I was talking about her previous arrest. We know that she was arrested previously.
Go ahead, ask a question.
Thank you. You also used the word necessary on page 24, but we agreed.
Where at, Counselor? I'm sorry.
Second, right before the quote by Uri Patrick and John Hall, attempt to stop that deadly threat would be necessary. Do you see that?
I'm sorry.
Starts the paragraph with Castleberry chose instead to draw, open, and slash. Do you see that? Mm-hmm. The last word, necessary?
Yeah, based on Detective Mitchell's perception of what is necessary. That's Graham v. Connor.
Don't talk over each other. If you ask a question, allow them to answer it.
In Graham v. Connor, it talks about the amount of force the officer finds necessary, not a third party.
Use of the word necessary, we all agree that's not part of the analysis.
No, it is with the amount of force the officer finds necessary. That's in Graham. But the amount of force in hindsight, based on a 2020 review, is not how that's factored in Graham v. Connor.
Right. So using the word necessary here doesn't mean you're changing the standard of review here.
No, it's the amount of force that a reasonably prudent and well-trained officer would have found necessary in the exact same circumstance.
And you would agree the fact that deadly force might be justified at one moment doesn't justify it categorically throughout an encounter, right?
I would agree with that.
Okay. You agree officers can act outside of their training, right?
But violation of their training is not a violation of law.
I didn't ask that. Officers can act outside of training, right?
Oh, they frequently do things that they've not been trained to do, unfortunately.
Officers can violate the law, right?
Yes.
There are bad apples in every profession, right?
In every profession.
In your use of force book, and I'll be clear about what we're talking about, you mention the need for officers to read the reaction of a suspect and determine if they need to dial back the use of force. That concept familiar? Can we start with yes? Is that, you recall that?
I'm sorry, I was answering the question, Counselor.
Well, I want to know if you recall it first.
Yes, it's consistent with training I've given and what I wrote in the book, yes.
Okay. So officers must reassess, and there's an ebb and a flow regarding the application of force, right?
There's a application of force, and then there is an assessment period or the reading, if possible. Some situations are over in fractions of seconds, and the assessment is only that the suspect is down and no longer a threat in a deadly encounter, for instance. Others are more prolonged, but there's an application. For instance, when a subject is resisting handcuffing and an officer does a knee strike, is the knee strike effective? Does the suspect stop, or do they continue to resist, or do they escalate in their resistance?
When did you look at the weapon involved in this case?
Well, I looked at photographs of the pistol. I've never examined the pistol, in person.
Okay. Did you hear anything, Carla?
You didn't look at the weapon, right?
In photographs, yes. In person, no.
And so, fair to say you didn't look at the holster or the knife or the clothing, right?
In photographs, yes. In person, no.
You talked about officers routinely saying, this is what I'm going to do and why. This was on your direct testimony. Officers routinely tell suspects what they're going to, I'm going to cuff you, I'm going to this, I'm going to do these things, right?
When talking about handcuffing, yes, you're under arrest, put your hands behind your back, I'm going to handcuff you for my protection of yours. That's a common saying in law enforcement.
And officers also say things like, show me your hands, hands up, drop the gun, things like that, right?
In different circumstances, yes.
You said on direct that Donna's back was against the dashboard, the defendant was being choked almost to the point of unconsciousness. She continued to resist and not comply with the instructions to submit. What instructions were given during that struggle?
Well, he said that you're under arrest. At that point in time, once he's been cut, it's a different set of circumstances. It's now survival. But I'm going to handcuff you for your protection, and for my protection of yours, were instructions.
Well, at the time you were talking about that very subject in that statement, you were talking about the struggle with him in her seat and her against the dash, and said didn't comply with instructions to submit. Were there instructions to submit during that struggle?
Well, as the struggle began, yes. But once she feloniously assaulted him, then it was she cut me, she's got a knife, etc.
What was the evidence you rely upon in saying that Mr. Mitchell reassessed? Reassessed before shooting and between his shots. What evidence did you rely upon in making that decision?
Well, his assessment was based, from the time he was cut, and then in that interim period is when she feloniously assaulted him by way of the foot against the neck, and then he made the decision to go for it, to go for the pistol. But his assessment was that she was armed with the knife at the point that she went from the front seat to the rear seat, and his statement is that he felt that she might slit his throat from behind.
What from the point he turned and began to fire did you rely on in deciding that he reassessed throughout? You said he reassessed throughout. What's the evidence you relied on?
Well, he's seeing movement by Miss Castleberry. She's attempting to kick him. She's moving from one side to another. Once again, he says he doesn't see the knife, but that doesn't mean the knife's not in her hands. He just said he didn't see it.
You indicated that you don't believe this is a change in circumstances because you said there was no substantial change because Donna was still in touching distance. Right?
Yes. I mean, the vehicle that we're talking about was a smaller four-door sedan, very cramped space in terms of the distance from back seat to front seat, and the entire time she was in the vehicle with the detective, she was within arm's reach.
She had no option to get any further from him than the back seat, right? I'm sorry, I couldn't hear over the call.
Sustained.
And I think we can hopefully agree that an officer just saying I was in fear for my life is not enough to justify a decision to use deadly force, just his statement alone. You have to articulate why, correct?
Well, and the facts and evidence are examined as well. For instance, the slash on the detective's hand, that happened, and that was a felonious assault.
The reason we look at this objectively reasonable analysis is we're looking to extract the unreasonable officer, right? The outliers.
Well, it's our responsibility, both the law enforcement investigators, expert witnesses such as myself and Mr. Patrick, is to examine these cases and determine if, based on our expertise and our experience, that they're within the law.
And I think we've established you and Mr. Patrick do not agree in this matter, correct?
I don't know what Mr. Patrick testified to. However, I have read his report. I disagree with some fundamental statements in his report.
Any redirect?
Briefly, Your Honor. May I inquire?
Yes, you may.
Thank you, Your Honor. Ms. Pritchard talked to you about your book, Armed Citizen's Guide to Self-Defense, correct?
Correct.
Is this case, Mr. Davis, about a private citizen or is it about a police officer?
It is about a law enforcement officer in the performance of his duty.
Is a citizen ever allowed to use armed defense against a police officer?
No.
Is this case about a citizen's house being burglarized?
No.
I want to talk to you about the standard that Ms. Pritchard has talked to you about and how it relates to the door being open. Do you remember that discussion?
I do, yes.
How do we analyze a deadly use of force incident?
At the moment that it's used based on the totality of the circumstances.
Through the eyes of who, sir?
The officer on scene in their shoes based on their perceptions and their experiences.
So not standing in Ms. Pritchard's shoes?
No, not in my shoes, but we have to project ourselves into Detective Mitchell's shoes at the moment that he used deadly force.
Standing in Andy Mitchell's shoes at the moment he used deadly force, right?
That is correct.
So whose beliefs about the situation are we supposed to take into account when analyzing whether or not a use of deadly force was justified?
Slow it down.
Just trying to be brief. So, whose beliefs about the situation are we supposed to be analyzing when analyzing whether or not a use of deadly force was justified?
The legal standard is the perception of the involved officer.
So if the perception of the involved officer did not believe the door was open, is it reasonable to believe that Donna Castleberry is still an imminent threat to his safety with regards to serious physical harm or death?
Door opened or closed, it's irrelevant. It's based on his perception of the threat of death or serious bodily injury.
So it's still reasonable?
It's still reasonable.
Ms. Pritchard talked to you about shot cadence, about how quickly you can fire a weapon. Have you ever fired a weapon quickly with a sliced hand, Mr. Davis?
No.
Would having your hand sliced affect your ability to rapidly fire quickly?
Potentially, certainly, and especially with the blood flow, et cetera, that would affect the operation of the pistol or revolver or the handgun.
Would having been choked affect your ability to fire quickly?
Yes.
Do you believe that Andy Mitchell's shot cadence is in fact reasonable given the totality of the circumstances in this situation?
In this situation, yes.
Along those same lines, sir, Ms. Pritchard talked to you about giving instructions, right? About giving instructions during an attack, correct?
Verbal orders, et cetera?
Yes,
Yeah.
sir.
Yes.
Can you give verbal orders while you're being choked?
Objection to leading questions.
What was that?
Leading.
Re-ask the question.
Thank you. Are you able, is a reasonable officer able to give instructions, to give verbal warnings as he or she is being choked?
The focus of a reasonable officer would be on survival. You're fighting with a subject armed with a knife that's already seriously wounded you and is pressing their foot up against your neck. The focus is on survival, and legal. There is no legal standard for giving verbal directions or orders at that point. The only in the law in Tennessee versus Garner is that verbal orders have to be given before shooting a fleeing felon, if feasible. Those are the only legal standards that I know of in terms of giving verbal orders prior to the use of deadly force.
Do you remember when Ms. Pritchard talked to you about Donna Castleberry potentially surrendering earlier this morning before lunch?
I'm sorry. It seems like a long time ago. I may not, Counselor. I'm not sure of the question.
Did she talk to you about a suspect potentially surrendering?
Yes. Yes.
Is it reasonable to believe that after the first shot that Andy Mitchell did not hear any other words Donna Castleberry uttered? Your Honor, I'm asking a yes or no question.
Re-ask the question.
What is it reasonable, Mr. Davis, for Andy Mitchell to believe that he heard or did not hear the shots? I apologize, that he heard or did not hear the words after the first shot was uttered.
Detective Mitchell would have to testify as to what he heard or didn't hear, but under those circumstances, with the effects of stress, as I talked about earlier, and the gunshots, it would be very hard to hear verbalization or comments made by Ms. Castleberry.
You mentioned on cross-examination that Donna Castleberry could have submitted to the arrest before Mitchell made the decision to use deadly force in order to get out of the car, correct?
At any point in that time, she made the decision to cut him, but she could have submitted at any point.
What other way, if any, exists? Does Donna Castleberry have a way out of that vehicle?
What other way? Feloniously assaulting the detective or killing the detective.
Thank you, Mr. Davis. I have nothing further.
Any questions as a result of those questions?
No, nothing.
All right, you can step down.
Thank you, Your Honor.
Leave everything there. We can take the water, I guess.
Okay, thank you.
Counsel, want to approach? Off the record. Any further witnesses on behalf of the state of Ohio?
Well, us.
On behalf of the defense.
Your Honor, with the exception of the submission of our exhibits, the defense would rest at this point in time.
Okay. Ladies and gentlemen, what we're going to do is take a 15-minute break. I have to do some work, so so it'll be about 15 minutes. Do not discuss this case among yourselves. Do not permit anyone to discuss it with you or in your presence. It is your duty not to form and express an opinion on the case until it is finally submitted to you.
All right.
Have a seat. Are you renewing your Rule 29?
Yes, Your Honor.
Are you going to have any rebuttal witnesses?
Okay.
What evidence are you guys moving in? Is that, what evidence are?
Exhibits?
Mm-hmm.
Yeah, just get the folder now. I'll walk through numerically. That's okay.
Oh, I caught you now. I caught you now.
These are yours. Do you have verdict form?
Have you guys seen verdict forms?
Rachel made them each a copy. I was just going to collect them after they were done.
No, but I have to put them in the right order. Okay, I then need the medical records. CV. Yeah. We haven't. Yeah, we haven't. I'm going to try to go through it now. Yep, because they were demonstrative, yeah. I'm going to go through them. Let me just put them in the order, and then I'm going to go real slow through all of them. Okay. The first one, Your Honor, is 6, 7. The first one, Defendant's Exhibit 1, Your Honor, is the bottom of the picture of the sandals that was testified to by Detective Shepard. Okay, right here. The second one, Your Honor, is, I believe, Exhibit number 3. This is the warrant that was pulled, as well as the second page of that warrant, just testified to by Detective Shepard.
Okay. A minute.
Then, Your Honor, our defense exhibits 5, which is just a closer picture of the knife.
Okay.
6 is the picture of the hand as taken by Detective Shepard at the hospital.
Okay.
7, Your Honor, is the defensive wound pictures, the defendant's 7th and 8.
Okay.
Not.
She's moved them out. There you go.
9 is the Ohio health records testified to by Detective Shepard.
No objection. Yeah, you may want to check that out.
We'll look for redactions, sure, absolutely. Set this here. 10, 11, and 12 are just scene photographs identified by Detective Shepard. And again, these are the same as they have, but make sure the record's clear.
No objection.
10, 11, 12. 14, Your Honors, again, picture of the handcuffs.
No objection.
And then, Your Honor, I believe the stipulation, do you want the stipulation, well, it's a joint exhibit number 7.
Yes, we agree.
Okay.
You stipulated, so it's going in.
Well, no, but I mean, I wasn't sure what to label it. So we did the 911 calls joint exhibit number 7.
Okay, that's fine.
Right. And then if Ms. Stevens, if you'll grab the CV, I think that's the last one.
May I approach, Your Honor?
You may.
Yeah, of course. I'll get it. I want to put this in.
Did I admit Patrick's CV?
Yeah, that's why, yeah.
CVs, but not report.
Right. Well, Loomis's report.
Right.
Yeah. Let's see, the CV's redacted for the first trial. That's why she gave you a new one. This is it. And I think, so the last one is Mr. Davis's CV, Defendant's Exhibit 24, and that was redacted because part of that he included his the testimony in the first trial. You want me to go to those again? Okay. Well, that would be all, yeah.
Give him the Carla, not me. What? Yeah. And then what I'm proposing is we.
I think he asked if I had any other additional arguments for Rule 29.
Did you rule on the Rule 29, or did we not do that yet?
Did you re-raise it?
Yeah.
Overruled.
Yeah, I'm sorry, you missed that part. Okay. We won. Oh, wait, Carla, yes, we need to look for the medical records to see if, that's why I set that one aside. It's 9.
seat. Any rebuttal evidence on behalf of the state of Ohio? At this time, ladies and gentlemen, I've given you a copy of the jury instructions. My wife hates to be read to, and so I'll let you guys read along with me. Members of the jury, you have heard the evidence and will hear the arguments of counsel. The court and the jury have separate functions. You decide the disputed facts, and the court provides the instructions of law. It is your sworn duty to accept these instructions and to apply the law as it is given to you. You are not permitted to change the law or to apply your own conception of what you think the law should be. A criminal case begins with the filing of an indictment. The indictment informs the defendant that he or she has been charged with an offense. The fact that it was filed may not be considered for any other purpose. The plea of not guilty is a denial of the charges and puts in issue all the essential elements of the offense. The defendant is presumed innocent unless guilt is established beyond a reasonable doubt. The defendant must be acquitted of an offense unless the state produces evidence which convinces you beyond a reasonable doubt of every essential element of the offense. Reasonable doubt is present when, after you have carefully considered and compared all the evidence, you cannot say you are firmly convinced of the truth of the charge. Reasonable doubt is doubt based upon reason and common sense. Reasonable doubt is not mere possible doubt, because everything relating to human affairs or depending on moral evidence is open to some possible or imaginary doubt. Proof beyond a reasonable doubt is proof of such character that an ordinary person would be willing to rely and act upon it in the most important of his or her own affairs. Evidence is all the testimony received from the witnesses, the exhibits admitted during the trial, and the facts agreed to by counsel. Evidence may be direct or circumstantial or both. Direct evidence is the testimony given by a witness who has seen or heard the facts to which the witness testifies. It includes exhibits admitted into evidence during the trial. Circumstantial evidence is proof of facts or circumstances by direct evidence from which you may reasonably infer other related or connected facts which naturally and logically follow according to the common experiences of mankind. To infer or to make an inference is to reach a reasonable conclusion of fact which you may but are not required to make from other facts which you find have been established by direct evidence. Whether an inference is made rests entirely with you. Direct evidence and circumstantial evidence are of equal weight. You may not make one inference from another inference, but you may draw more than one inference from the same set of facts. The evidence does not include the indictment or the opening statements or closing arguments of counsel. The opening statements and closing arguments are designed to assist you. They are not evidence. Statements or answers that were stricken by the court or which you were instructed to disregard are not evidence and must be treated as though you've never heard them. You must not speculate as to why the court sustained an objection to any question or what the answer might have been. You must not draw any inference or speculate on the truth of any suggestion included in a question that was not answered. You are the sole judges of the facts, the credibility of the witnesses, and the weight of the evidence. To weigh the evidence, you must consider the credibility of witnesses. You will apply the tests of truthfulness which you apply in your daily lives. These tests include the appearance of each witness upon the stand, the witness's manner of testifying, the reasonableness of the testimony, the opportunity the witness had to see, hear, and know things concerning the testimony, the accuracy of the witness's memory, frankness or lack of it, intelligence, interest, or bias, if any, together with all the facts and circumstances surrounding the testimony. Applying these tests, you will assign to the testimony of each witness such weight as you deem proper. You are not required to believe the testimony of any witness simply because he or she was under oath. You may believe or disbelieve all or any part of the testimony of any witness. It is your province to determine what testimony is worthy of belief and what testimony is not worthy of belief. The testimony of the defendant is to be weighed by the same rules that apply to other witnesses. Generally, a witness may not express an opinion. However, one engaged in a particular profession may express an opinion because of their education, knowledge, and experience. Such testimony is admitted for whatever assistance it may provide to help you arrive at a just verdict. You must decide what weight, if any, should be given to the testimony of an expert. In determining its weight, you may consider the expert's skill, experience, knowledge, veracity, familiarity with the facts of this case, and the usual rules for testing credibility and determining the weight to be given to testimony. The hypothetical questions which instruct the experts to assume that certain facts were true and to give an opinion based upon such assumptions have been asked. You must determine whether the assumed facts upon which the experts based his opinion are true. If any assumed fact was not established, you will determine its effect upon the opinion of the expert. You should not decide any issue of fact merely on the basis of the number of witnesses who testify on each side of an issue. Rather, the final test in judging evidence should be the force and the weight of the evidence, regardless of the number of witnesses on each side who testified to an issue. The testimony of one witness, if believed by you, is sufficient to prove any fact. Also, discrepancies in a witness's testimony or between his or her testimony and that of others, if there are any, does not necessarily mean you should disbelieve the witness, as people commonly forget facts or recall them differently after the passage of time. You are all aware of the fact that two persons who are witnesses to an incident may often see or hear it differently. And concerning the discrepancy of any witness's testimony, you should consider whether such difference concerns an important fact or a trivial fact. Count 1. The defendant is charged with murder in count 1 of the indictment. Before you can find the defendant guilty, you must find that the state has proved beyond a reasonable doubt that on or about the 23rd day of August 2018 in Franklin County, Ohio, the defendant caused the death of another as a proximate result of the defendant's committing or attempting to commit felonious assault, an offense of violence, and a felony of the second degree. The offense of felonious assault is knowingly causing or attempting to cause physical harm to harm with a deadly weapon. A person acts knowingly, regardless of his purpose, when the person is aware that the person's conduct will probably cause a certain result or be of a certain nature. A person has knowledge of circumstances when he is aware that such circumstances probably exist. Because you cannot look in the mind of another, knowledge is determined from all the facts and circumstances and evidence. You will determine from these facts and circumstances whether there existed at the time in the mind of the defendant an awareness of the probability that physical harm with a deadly weapon could result from his actions. Cause is an act or failure to act which in the natural and continuous sequence directly produces death and without which it would not have occurred. Cause occurs when the death is natural and foreseeable result of the act or failure to act. A criminal attempt is when one knowingly does or admits to do anything which is an act or an omission constituting a substantial step in a course of conduct planned to culminate in his commission of the crime. To constitute a substantial step, the conduct must be strongly corroborative of the actor's criminal purpose. Preparing, planning, and arranging the means for the commission of the crime does not constitute an attempt. Physical harm to person means any injury, illness, or other physiological impairment, regardless of its gravity or duration. Deadly weapon means any instrument, device, or thing capable of inflicting death and designed or specifically adapted for use as a weapon or possessed, carried, or used as a weapon. If you find that the state has failed to prove beyond a reasonable doubt all the elements of felonious assault, or if you find that the state has failed to prove beyond a reasonable doubt felonious assault was the proximate cause of Donna Castleberry, then you must find the defendant not guilty of murder in count 1 and sign the appropriate verdict form. If you find that the state proved beyond a reasonable doubt all the elements of felonious assault, and you find beyond a reasonable doubt the felonious assault was the proximate cause of the death of Donna Castleberry, you must then go on to consider an additional factual question. You must decide whether the defendant has proven by a preponderance of the evidence the affirmative defense of justification. The affirmative defense of justification. In both counts, the defendant is alleging the affirmative defense of justification. The defendant, Andrew K. Mitchell, maintains that his use of deadly force against Donald Castleberry was reasonable and lawful in the exercise of his official duties as a police officer and therefore justified. because he reasonably feared that the actions of Donna Castleberry would cause death or serious physical harm to Andrew K. Mitchell. To establish the defense of justification, the defendant must prove he was justified in using deadly force by a preponderance of the evidence. Preponderance of the evidence means the greater weight of the evidence, that is, evidence you believe because it outweighs or overbalances in your mind the evidence opposed to it. A preponderance means evidence that is more probable, persuasive, or of greater probative value. It is the quality of evidence that must be weighed. Quality may or may not be identical with quantity. In determining whether or not an issue has been proved by a preponderance of the evidence, you should consider all the evidence bearing upon the issues regardless of who produced it. If the weight of the evidence is equally balanced, or you are unable to determine which side of the issue has a preponderance, then the defendant has not established such a defense. If the defendant fails to establish the defense of justification, the state must still prove to you beyond a reasonable doubt all the elements of the crime charged. If you find the defendant met the burden, your verdict must be not guilty. Or if you find the defendant met the burden, your verdict must be not guilty. An officer is entitled to use deadly force in apprehending a suspect where the officer reasonably believes at the time that deadly force is utilized that the suspect poses an immediate threat of serious physical harm to the officer. If a suspect's conduct threatens the officer at a level of serious physical harm or death, an officer's use of deadly force to mitigate that threat will be deemed reasonable. Immediate threat to the officer of serious physical harm or death will permit him to respond with deadly force. Whether an officer reasonably perceived a threat must be assessed objectively. The reasonableness must be judged from the perspective of a reasonable officer on the scene rather than with 20/20 vision of hindsight. The relevant legal consideration is not what this defendant officer should have known or done, but rather what the reasonable officer placed in his shoes could have believed about the situational need for deadly force in reacting to an imminent threat. You are strictly forbidden from using the 20/20 vision of hindsight. Unlike judges and juries, officers on the beat are not afforded the luxury of armchair reflection. You must avoid substituting your personal notice of proper police procedure for the instantaneous decision of the officer at the scene. The test of reasonableness is an objective one. The focus is specifically on the moment he used his weapon and the moments directly preceding it. The question is whether an officer's action were objectively reasonable in light of all the facts and circumstances confronting him, without regard to his underlying intent or motivation. Instead, you are required to use the perspective of the reasonable officer on the scene, standing in the defendant officer's shoes, perceiving what he then perceived, acting within the limits of his knowledge or information as it then existed. The standard of the reasonable officer takes into account not only the specialized training and experience of police officers, but also the public safety rule for which they are uniquely employed. You must consider the conduct of Donna Castleberry and decide whether her acts caused the defendant to reasonably and honestly believe he was about to be killed or receive great bodily harm. The calculus of reasonableness must embody allowance for the fact that police officers are often forced to make split-second decisions in circumstances that are tense, uncertain, rapidly evolving about the amount of force necessary in a particular situation. In determining what is reasonable, it is important to consider the facts and circumstances of each case, including the severity of the crime at issue, whether Ms. Castleberry posed an immediate threat of serious physical harm or death to Mr. Mitchell at the time the deadly force was employed, and whether she was actively resisting or attempting to evade arrest. In evaluating reasonableness in the threat perception cases, other considerations may include, but are not limited to, attempts to evade the officer, furtive gestures and glances, sudden turns, and ignoring of commands. Other relevant considerations may include the suspect's demeanor, the size and stature of the parties involved, whether the suspect was intoxicated and non-compliant, whether the suspect is or appears to be violent and dangerous, the duration of the confrontation, whether it occurs during a chase or an arrest, the possibility the suspect may be armed, and the number of suspects with whom the officer must contend. Actual possession of a weapon is irrelevant as long as the officer reasonably believes the individual possessed a weapon. The law does not require police officers to wait until a suspected uses harm to confirm that a serious threat of harm exists. The objectively reasonable officer can be mistaken, even if the officer had a mistaken belief, as long as that mistaken belief is reasonable under the then existent circumstances. The officer is justified in using deadly force. If an officer reasonably but mistakenly believed that a suspect was likely to fight back, for instance, the officer would be justified in using deadly force. If you find that the officer held a reasonable but mistaken belief as to the facts that prompted him to act, then the officer is justified and your verdicts must be not guilty. If you find that the defendant did not prove justification by a preponderance of the evidence, and the state proved the elements of the considered offense beyond a reasonable doubt, then your verdict must be guilty. If you find that the state has proven beyond a reasonable doubt the elements of murder, and the defendant has not proven by a preponderance of the circumstances the affirmative defense of justification, you should not immediately render a guilty verdict on count one. Instead, you should continue your deliberation by moving on to count two. Count two, the defendant is charged with voluntary manslaughter in count two of the indictment. Voluntary manslaughter is knowingly causing the death of another while the defendant is under the influence of sudden passion or in a sudden fit of rage, either of which was brought on by serious provocation occasioned by Donna Castleberry that is reasonably sufficient to incite the defendant into using deadly force. Before you can find the defendant guilty of voluntary manslaughter, you must find that the state proved beyond a reasonable doubt that on or about the 23rd day of August 2018 in Franklin County, Ohio, the defendant knowingly caused the death of Donna Castleberry. I have already defined knowingly for you. The defendant is alleging defense of justification in count two. I have already defined justification for you. Being under the influence of sudden passion or in a sudden fit of rage, either of which is brought on by serious provocation occasioned by Donna Castleberry that is reasonably sufficient to incite the defendant into using deadly force, is a mitigating circumstances. Provocation is a mitigating fact that, while not outright justification, reduces the deputy's or the defendant's culpability. Neither the state of Ohio nor the defendant, Andrew Mitchell, has the burden of proving that the defendant was under the influence of sudden passion or in a sudden fit of rage, either of which was brought on by serious provocation occasioned by Donna Castleberry that was reasonably sufficient to incite the defendant into using deadly force. Nonetheless, you may consider evidence presented by either side in determining whether provocation has been established by a preponderance of the evidence. The passion or rage must be sudden and in great nature and intensity, and it must exist at the time of the act that caused the death of Donna Castleberry. The passion or rage must be brought on by serious provocation by Donna Castleberry. Provocation to be serious must be reasonably sufficient to incite the defendant into using deadly force. And to determine whether the provocation was reasonably sufficient to incite the defendant into using deadly force, you must consider the emotional state of the defendant and the conditions and circumstances that surrounded him at the time. Preponderance of the evidence has already been defined for you. And determining whether or not the mitigating circumstances have been proved by a preponderance of the evidence, you should consider all evidence hearing upon that issue regardless of who produced it. Deadly force means any force which carries a substantial risk that it will approximately result in the death of any person. If you find the state has not proven beyond a reasonable doubt that the defendant knowingly caused the death of Donna Castleberry, you must find the defendant not guilty of voluntary manslaughter, or if you find the defendant did not cause the death of Donna Castleberry while under the influence of sudden passion or a sudden fit of rage, either of which was brought on by serious provocation by Donald Castleberry that was reasonably sufficient to incite Andrew Kirk Mitchell into using deadly force, you must find the defendant not guilty of voluntary manslaughter. If you find that the state has proven beyond a reasonable doubt that the defendant knowingly caused the death of Donna Castleberry, and you find that the defendant did so while under the influence of sudden passion or a fit of rage, either of which was brought on by serious provocation occasioned by Donna Castleberry that was reasonably sufficient to incite Andrew Kirk Mitchell into using deadly force, you must decide if the defendant has proven by a preponderance of the circumstances the affirmative defense of justification. The affirmative defense of justification has been defined for you. If you find that the state has not proven beyond a reasonable doubt that the defendant knowingly caused the death of Donna Castleberry, then your verdict on count 2 should be not guilty. If you find the state has proven beyond a reasonable doubt that the defendant knowingly caused the death of Donna Castleberry, and you find that the defendant did so while under the influence of sudden passion or a sudden fit of rage, either of which was brought on by serious provocation of Donna Castleberry that was reasonably sufficient to incite Andrew Kirk Mitchell into using deadly force, and you find that the preponderance of the evidence, the affirmative, you do not find. Hold on. Preponderance of the evidence, the affirmative defense of justification, then your verdict as to count 2 should be not guilty. If you find the state has proven beyond a reasonable doubt that the defendant knowingly caused the death of Donna Castleberry, and you find that the defendant did so while under the influence of sudden passion or in a sudden fit of rage, either of which was brought on by serious provocation by Donna Castleberry that was reasonably sufficient to incite Andrew Kirk Mitchell into using deadly force, and you find the defendant has not proven by preponderance of the evidence the affirmative defense of justification, then your verdict as to count 2 should be guilty. In this event, you would then render no verdict on count 1, a murder, unless the verdict was not guilty. If you find that the state has proven beyond a reasonable doubt that the defendant knowingly caused the death of Donna Castleberry, and you do not find that the defendant did so while under the influence of sudden passion or rage, either of which was brought on by serious provocation by Donna Castleberry that was reasonably sufficient to incite Andrew Kirk Mitchell into using deadly force, and you find the defendant has not proven by a preponderance of the evidence the affirmative defense of justification, then you should return to your decision in count 1, murder, and render no verdict as to count 2 unless your verdict is not guilty. In short, a guilty verdict on count 2 precludes a guilty verdict to murder in count 1. You should find the defendant guilty of only one of these 2 counts in the indictment. You are permitted, however, to find the defendant not guilty on both counts. I'll read the verdict forms. You are not to place any emphasis on the order in which I read these forms. You will have 4 forms. Here are the forms. You can see a case caption, State of Ohio versus Andrew Mitchell. First verdict, we the jury upon our oath and law and evidence case find the defendant guilty as murder as charged in count 1 of the indictment signed this blank day of April 2022 by each and every juror. You can see there's 12 lines to sign on this. Next verdict, case caption, State of Ohio versus Andrew Mitchell. We the defendant on our oaths and law and evidence in this case find the defendant not guilty of murder as charged in count 1 of the indictment signed this blank day of April 22 by each and every jury. Again, 12 signature lines, one of which is the foreperson. We, the jury, upon our oaths and law and evidence in this case, find the defendant guilty of voluntary manslaughter as count 2 of the indictment, signed this blank day of April 2022 by each and every juror. Again, 12 signature lines dated. The fourth one, we, the jury, upon our oaths and law and evidence in this case, find the defendant not guilty of voluntary manslaughter as charged in count 2 of the indictment, signed this blank day of April 2022 by each and every juror. 12 signature lines. You may not discuss or consider the subject of punishment. Your duty is confined to the determination of guilt or innocence of the defendant. In the event you find the defendant guilty, the duty to determine the punishment is placed by law upon the court. You must not be influenced by any consideration of sympathy or prejudice. It is your duty to carefully weigh the evidence, to decide all disputed questions of fact, to apply the instructions of the court to your findings, and to render your verdict accordingly. In fulfilling your duty, your efforts must be to arrive at a just verdict. Consider all the evidence and make your finding with intelligence and impartiality and without bias, sympathy, or prejudice, so that the state of Ohio and the defendant will feel that their case was fairly and impartially tried. If during the course of the trial the court said or did anything that you consider an indication of the court's view on the facts, you are instructed to disregard it. What we're going to do now, we're going to do closing arguments. The state of Ohio has the opportunity to go first. The defense then can do their closing arguments, and then the state of Ohio has an opportunity to do rebuttal closing. Are there any closing arguments on behalf of the state of Ohio?
Get my tech bag at this thing here.
Put the lights out.
Ladies and gentlemen, this is Donna Castleberry. Donna died at the hands of Andrew Mitchell, as you've heard, back in August 2018, at the hands of an admittedly lax police officer. We've talked a lot about the reasonable officer. I'm going to make sure I stay out of your way and move back this way. Can everybody see? Thank you. I've talked a lot about the reasonable police officer here. I submit to you, he's not the prudent, reasonable, well-trained officer we're talking about. He's lax, he was sloppy, he was arrogant. He had no badge, he had no walkie, he had a knife in his back seat that he hadn't turned into the property room. He doesn't text on his cell phone to let others know that he's looking at one. Something they said was kind of a standard practice. You let people know, hey, I've got one here, I'm looking at one. He said he didn't have time, that she was coming up on him too quick. But listen to the audio component of that video. You can hear some paper shuffle, and then you hear probably about 50 seconds. Enough time when a cell phone's in your lap to send a quick text. He knows his backup is tied up. He said they're 5 to 6 minutes drive away, and they're on an arrest. So they're at least, if they just finished that arrest, 5 to 6 minutes away. He takes her to an area he says that she dictates, but you can listen for yourselves and decide if you think that's what happened. He parked up against the building. He said he did that because there was no one near to help him out if things went south. So he parked up and trapped her in, even though that wasn't his usual practice. He still went and tried to arrest her. Nobody had any idea where he was, and he was so desperate to make this misdemeanor arrest that he violates all of these safety practices. Talked about, I think most of the vice witnesses said, these girls always have knives, they jump from cars, they're high on drugs, it's so dangerous. Yet, he puts himself in this position without anyone having a clue where he's at. And I'm not saying this goes to whether his decision to use force was reasonable. We know that doesn't. But what it does tell you is whether or not he's believable, whether or not he's well-trained, whether or not he acted like the reasonable officer standing in his shoes. There's a sense of arrogance. He knows she's scared. He admitted it. There were at least a couple statements he made because she looked nervous, she looked scared. She didn't believe he was a police officer. She said that. But he didn't have any regard for that fear at the point where she says to him, I know who you are. They're showing your picture. You're out here kidnapping women. That's when everything goes downhill. He said, I asked him why he didn't call 911. First, I think he said he didn't have his phone, and then he acknowledged it was in his lap. So just call somebody. Call Laura Evans. Call the people at the library. Call somebody from dispatch. Say you need help. Something very easy and reasonable to do. Exit the car. Let her sit there and wait. Wait for the backup to arrive. I'm not going to touch you. You're good. I'll just stand right here and wait. And I know these things don't go into whether or not the shooting was reasonable, but is he that well-trained officer? We see that, yes, that instead of staying and waiting, he's the one who gets mad. Now that you have all the evidence, you're going to notice a lot different things from this video. You've seen it a few times. I implore you, when you watch on the small screen, it will look much clearer than it does here. It's not perfect. It will look better. Watch it over and over. Watch those movement patterns. See what you can determine from this.
My daughter's birthday.
Kidnapped or anything. You got no weapons on you, do you?
Hold on, let me see it.
You got any warrants? 50 chat? Come on, I know we can get them.
So where's your bag?
I have one. I'm falling apart. Don't worry, it's my handcuffs. You don't be all who I am.
Oh, I didn't say that.
I'm gonna cuff you just for my safety. I'm not gonna do that to you. I'm just gonna cuff.
No, I'm not giving you any handcuffs.
You're being under arrest. If you don't have any warrants, I'll let you go.
Okay, well, I'm gonna have to take some more type of ID about it.
I just showed you my ID. I don't have my badge on. I'll call my buddy. Okay?
You're gonna have to do that. I'm not gonna call that. I'll go ahead and call myself.
I've never had any of this happen like this way at all. So
Why? Because I don't have my badge. I left on my police shirt.
you don't have your badge, you don't have your walkie-talkie.
Yeah, I do.
You don't have any of that.
You too.
What is that? There's no way to do it.
Complain.
Municipal court.
Vice.
Right, you get that in the car.
Right. So I'm a policeman.
You can get that out of the car.
Handcuffs, ID, what do you want?
Can you help me, please?
Help you what?
Call the police for me.
I am the police.
You're not the police. I know you're not. And that's false identification right there. That can get you in a lot of trouble with doing stuff. When he's tracking me and saying he's a police officer and he's not a police officer.
Yes, I
He's
am.
acting like he's a police officer. And he's not. He has this in a fake ass bag. Kidnapping women. I've already heard about him and he already is wanted. This cops have been showing the pictures. You know that, right?
Yeah, all right.
They've been showing the pictures.
City fuck you. I'm glad I can't.
Don't put your hands on me. Don't put your hands on me. Do not put your hands on me. Do not put your hands on me. Don't put your hands on me. Help! Help!
She got a knife.
Help!
Cut me.
Help! Get off of me!
Just cut me.
Help! Help! Help me, please. I'm in the back door. Help me. I'm in the back door. These guys got me. Help me. Get off of me. Please help me. Please help me.
Fucking nightmare.
After reviewing that video, and let me forward it again, I'm sorry. Let's look at the testimony, Mr. Mitchell. To ask yourself, is it believable? Did you find him credible? Do you find it matches with that audio and video and what happened here? He paints Donna as escalating as soon as she yells to the citizen. I think on the stand, he said, well, she's trying to avoid going to jail. There's an insinuation she's trying to go score dope. Those aren't things he knew at the time. Those are things to try to conform to the evidence that we now have. The escalation, when she yelled to the citizen, as claimed, really didn't happen until he said, fuck you, I'm gonna have to handcuff you, because she said, you're gonna get in trouble. That's false identification. They're showing your picture and you're trying to kidnap women. That's when things got heated. That's when things escalated. He maintained she was a deadly threat the entire time until the last shot. That was his testimony. Said her body language was kicking feet, flinging arms, yelling up until the very end. think his testimony was that before she called to the bystander, she was banging on the dash. Listen to the audio, see if there's any noises, any visibility on that video, banging on the dash. Reluctantly admitted she was scared, and then said, well, then it was just faking. It's this crafty acting by Donald Castleberry, who doesn't know she's being recorded, who yells out for the police. She's yelling for the police. And he's saying she doesn't want to go to jail, but she's asking for the police. He refuses to admit he got angry. He says fed up. Can't use the word anger. Have to avoid the word provocation. He said Donna was trying to kill him the entire time, and described very vividly for us how she was sitting on the center console. She's sitting up against that dash, her head up near where there's a rearview mirror, kicking with her left foot. Very deliberate demonstration of the left foot, which we now know he really doesn't know which foot, but it matched the DNA. So, trying to conform to the evidence rather than what really happened or what he remembers happened. So look at that video. See if you believe that Donna Castleberry was sitting right there next to that steering wheel with her foot on his neck. Or does the video suggest he was on top of her, consistent with her saying, get off of me? He's leaning over to her side. She might very well be kicking, but is he trapped against that headrest? Is he pinned in? The story's better if he's pinned in that seat, because then he's trapped. But if he has the ability to move, to be on top of her, to be in a dominant position, that changes the equation, right? So you review the video. Think about the statements of Donald Castleberry and decide what makes sense. He said he was fighting for his life until the last shot. She's in the back seat. He has opened the door. He has admittedly at least put a foot out. And he has options, as you've heard. And I'll discuss that more in a minute. As I mentioned, he said it has to be my left foot because there's DNA on her shoe. There's a lot of explanations, as you've heard, for how her DNA, or his DNA, I'm sorry, could be on her shoe. And then when I said, well, wait, she might have kicked your leg, your hand. No, I don't think she did. It's got to be the neck. It's got to be the neck. DNA doesn't tell you it came from the neck. He told Detective Pilya that he didn't take her to the area where the others were because the precinct gets upset if you take them there, and that she picked the spot. But I ask you whether the evidence suggests that. And then he testified, well, on direct, it wasn't about that. It was she picked the spot and no mention of taking to precincts or problems with anybody getting upset if you take them anywhere else. What he said to Donna in this audio, a little bit different than his description. Here it was, I told her, Columbus police, you're under arrest. Granted, he said, police, you're under arrest. But there's little bits that get added. It makes it just a little bit better. Columbus police. We'll sit here calmly and I'll just text my partner. He said I'll text my partner. He also said he texts his buddy. But sit here calmly, adding bits like that. Does it mean anything? Maybe not. But I ask you to consider it as to whether he's trying to make the story a little bit better. He said he had no time to tell the others he had one, but as I mentioned, I suggest there's about 51 seconds of time before she gets in that car. He claimed initially that he told the 911 bystander to call, and he said, well, I wanted him to call to get someone there quicker for me. Does that make sense? He said he was willing to sit there and wait for backup to come. But he wasn't, because he got mad, because she was still worried about who he was. And that's when he just said, fuck you, because she was calling for help. If you want help to come, then fine, there should be nothing wrong. You're happy with what she said. You say, yes, please do. And you sit and you wait. I already mentioned that he waited to cuff her until the kidnapping accusation. He didn't do it right when she called out. Again, hitting the dash, being belligerent. I tell you, the video belies this. She's yelling, get off me. And he doesn't want to admit he saw the knife. He says, I didn't see the knife until after I was cut. The tape suggests, he says, she's got a knife. 2 seconds later, she just cut me. So he sees the knife, and then he gets cut. Ask yourselves, why does he not want to admit he saw the knife? Is there a reason to not admit you ever saw the knife? Because you don't want to admit you didn't see it in the back seat. You want to act like it's this easy to hide object that Donna was concealing to begin with. Ask yourselves when considering his credibility whether he did things to try to make the story better. We have the DNA. We have on direct. He said maybe Donna was trying to cut him in the rear of the car. Mr. Collins put a picture up and said, a small cut, and said, do you know when you received the other one? No, I don't. You don't know if it happened right away or whether it happened when she was in the back seat. And he said, correct. And then I very clearly established with him that every statement was that the cuts were sustained in the front, both of those cuts. This was not truthful testimony. We have a sudden accusation that Donna's trying to not go to jail or score dope, things he never said before. He didn't say in his written statement that he prepared with the assistance of his lawyers about a month after, and then an interview with Detective Pilya. That was something that came to light later. He said he fired to the passenger side, the building as his backdrop. He demonstrated with his left hand that he fired towards the wall, towards the passenger compartment, he said. But the physical evidence shows he fired from the front to the back. But his initial statements were that he fired across, but the physical evidence didn't end up supporting that. He said the door was closed. We clearly know the door was not closed. And he said he was trapped in his seat. And again, we know he wasn't trapped in his seat. We know he opened the door and got out of that seat. His initial statement was, I was trapped in my seat, the door was closed the whole time, I've got my seatbelt on, I'm firing across my body, I'm turning and I'm firing. In fact, he stepped out, he could pivot, he could turn and look at her, and he could fire. He could assess. Then the gun jammed. The gun coincidentally jammed at the exact moment he decided to fire shooting, you said. Let's focus on the back seat. She's trying to kill him at the time he's firing in the back seat, he said. She's still trying to kill me. She's in the back as far as she can possibly move. She can't get any further away with those child locks on. He doesn't see the knife. He doesn't ever get cut. He doesn't say, I saw her coming towards me with the knife. She's in the back. She's saying things. Okay, okay, sorry, no. Okay, okay. What does that look like? What do you think that looks like? What do you think her actions look like in the back seat? Was she moving? She probably was moving. She was probably trying to check one door and then check the other door. Would you expect her to not be moving? Does movement indicate threat just by virtue of being in the back seat, trying to get away from somebody she thinks is a kidnapper? You expect her to just be stationary in the back? He said, when I asked what she was doing in the back, kicking, yelling, wrestling, it was an ongoing battle. The moving around was the attempt to kill him. Not coming closer to me, not leaning over the seat, kicking, yelling, screaming, yelling, but I don't know what she was yelling, but she was yelling. And then we know the knife was found on the front. We know he was never cut again. We know there's no cuts in the car. Donna's not been cut. The knife is out of play. He has to account for each shot he takes. He's responsible for every shot. You've got the expert testimony to consider. The pauses, the shot cadence here, as Mr. Patrick said, these are not usual. This is very unusual to have those sort of pauses for an officer who claims to be trying to save his life. Hand switch or not, that doesn't take an extraordinary amount of time to switch your hand and to fire. According to Josh Durst, I believe it's flight path 3, he believes the muzzle had to be beyond the headrest because there's no hole in the headrest in that flight path. And there would be a hole based upon where that flight path is if he had been in the driver's compartment area. So he was over that seat, hand over that seat, the gun had to be, firing flight path 3. Getting closer to Donna. Even if we take Mr. Mitchell at his word, we accept everything he says happened in the car is true. He had the ability to create time and distance. That is critical here. That door opened, whether he remembers it or not now. He opened it. He stepped out. He was relying on instincts. Things that people just regularly do, things trained officers do. Open the door, step back. Commands, show me your hands, drop the knife, things like that. Then Mr. Patrick said, you expect from officers that you typically see. She's saying things like, help me please, open the back door, help me, help me, help me. Are those the words of a determined, aggressive, female, violent attacker? When you consider whether or not she's an imminent threat, you have to look at her actions and her words. If she's saying, I'm going to kill you, that's certainly more aggressive. If she's saying things like, help me, you need to consider all that. An officer must consider words when deciding if someone's an imminent threat. They don't have to necessarily believe it, but it's something to listen to, something to consider, and we get to objectively review whether a reasonable officer would have considered those words and how he would have interpreted them. If she had a knife and she wanted to be a determined aggressive killer, she certainly could have easily done so. There's no evidence she ever went at him. His testimony was he decided he was going to let go of her hands, and after he let go of her hands, he decided he was going to let go of her hands and reach for his gun and shoot as fast as he could. But things had changed. The determination in his mind at that moment doesn't make it reasonable after he undoes the seatbelt, opens the door, reaches for the holster, pulls it in front of him, unsnaps it, gets the weapon out, and then begins to fire. He has to look at what she's doing. There's a duty to see what she's doing at that time. You cannot categorically decide to shoot somebody because you may have been justified earlier. There was time to turn around and see what she was doing. And he says he turned the other way and just fired 2 to 3 shots, didn't even look at her. Yet Mr. Davis says, well, she could, okay, surrender. Well, you got to look at her first to see that. You don't shoot blindly. He failed to reassess the changing circumstances. He had already made up his mind. As you consider this expert testimony, decide who to believe. Ask yourselves, who was candid? Who conceded things? Who answered clearly? Who droned on? Mr. Patrick, I submit, conceded a lot of things. He admitted if Andy Mitchell had shot right after that cut, he would have been justified. He could have done it then, but he couldn't do it later. Mr. Patrick is probably one of the most well-known. According to Mr. Davis, he and Mr. Hall, they're the giants on which his learning has occurred. They're the teachers. Mr. Patrick was involved in State versus White, the leading Ohio case. Does he know what he's talking about? Does he know what a reasonable police officer does? Does he know how to apply the factors? He said this is only the second time he's testified against an officer. Is there something Mr. Patrick gains by coming in here and testifying for the state and testifying against an officer? Ask, does he have any motive to make this opinion up or to come to a certain conclusion? This one's an outlier. This isn't what he usually sees. This isn't what he usually expects. Mr. Davis considered selective information. He doesn't even consider the door being open. He doesn't mention the door open in 26 pages. Yet he quotes Mr. Patrick many, many times. He sings his praises when it suits him, but he's misguided here. Well, I got to disagree here. Does that make sense? As I mentioned, Mr. Patrick's candid with you. He told you, we don't have to believe what Andy Mitchell says if the evidence belies that point. We don't have to believe that she was choking him on the dash with her foot if the objective evidence suggests he was not trapped in his seat and she was not up against that dash. We don't have to take it as fact just because he says it or says he perceived it. The actions by Donna helped Mr. Patrick come to his conclusion. He said she wasn't a continued threat the entire time. She fled to the back. She was saying things like, I'm sorry, I'm sorry. He said if it was a knife attack, he would expect serious wounds. He would expect far more than the 2 cuts that happened in the front. He would expect cuts in the car. He indicated officers instinctively, well-trained officers give warnings, instinctively. In fact, too many officers often start shouting commands, making things confusing sometimes. It's what they do. It's what they're trained to do. He thought it was unusual. That didn't happen here. And he said it was reasonable to infer she was trying to give up. He said a reasonable officer would use the open door to create space and give time to reassess, and he had that opportunity. He opened the door and he did step out. He said officers have to be in a constant state of reassessment. That's what they're tasked with. They're given great power. With that comes great responsibility. Mr. Patrick has testified in over 150 cases. He said he doesn't see this kind of shot case. He saw it once. In a Chicago case, I believe he said. His extensive experience shows that officers shoot rapidly to save their lives. And he also indicated, and I think Mr. Davis agreed on this point, Officers can shoot at least 4 to 6 rounds a second. We've got 6 rounds in approximately 13 to 14 seconds here. If you play out 13 to 14 seconds, that is a long time for somebody fighting for their life. The event duration's about 8 minutes. The time from fuck you to she's got a knife was 14 seconds. And then she just cut me came 2 seconds later. The time from she's got a knife until the first shot is fired is 47 seconds. Then shots 1 to 2 took about a second. Shot 3 comes about 2 seconds later. Shot 4, another 3 seconds. Shot 5, 4 seconds later. Shot 6, 2 seconds later. Time to fire the shots, about 13 to 14 seconds. Let's look at the testimony of Mr. Davis.
Does council want to approach real quick? Not on the record. No. You may continue.
You can evaluate the credibility of Mr. Davis. Think about what he said. Look at the factors he considered. Look at the things he left out. He said officers should go to the threat. But in this circumstance, I think we established this isn't like a school shooting, run to the threat. This is a contained threat. This was different. You don't have to go to the threat when you're stepping from a car and you have an ability to create distance. He accepts Mr. Mitchell's statements as the basis of his opinion. So if what he has relied on is refuted by the evidence, then his opinion is not correct. His report was replete with terms like determined, violent, female aggressor, and attacker. I suggest to you those kinds of terms show bias. If we rely on Davis, because Donna had a knife and he got cut, that she was a threat the entire time just because of the proximity, because she was always within arm's length, because she couldn't get out of that car. His theory is she was a threat the whole time. She had no option. As long as he wasn't sure where the knife was, he had a right to shoot her, in their opinion. ignoring the ability to make space. Now you're going to hear about justification. Was Mitchell's use of force objectively reasonable viewed through the eyes of a reasonable officer? And we've heard these terms. Did he reasonably believe at the time force was used she posed an immediate threat of death or serious physical harm? And he can be mistaken, but that must be reasonable. If we prove our case beyond a reasonable doubt, you consider justification. And if you find he proved justification by preponderance of the evidence, then you'll find him not guilty. But if he didn't prove justification beyond a preponderance, and we proved our case, you'll decide which of the counts we proved. We judge this from the perspective of a reasonable officer on the scene, not in hindsight. Looked at the totality of circumstances we've heard. The judge has given you the instructions. The standard of the reasonable officer takes into account the specialized training and experience of police officers. We account for the fact that they're trained. In considering the reasonableness, the facts and circumstances, I think Mr. Patrick and Mr. Davis went through these. Things like size, strength, skill, but also the ability to create distance, containment, cover, and time. Did she pose an immediate threat at the time he used deadly force? This is where you're going to consider the conduct of Donald Castleberry, what she was doing, what she was saying, and decide whether her acts caused him to reasonably believe he was about to be killed or harmed. She's in the back seat. There's no signs of the knife. She's yelling, "Help me, get off me." Are those the words of an attacker? He was not yelling, "Put the knife down, stop," or anything to indicate she had it or was coming after him. He wasn't yelling anything anymore about a knife, and he was never cut again. As we said, then he had time before he fired. Donna's actions, she was polite but suspicious. She asked a citizen for help. Ask yourself if that's aggressive escalation or not. He's cut. There's a struggle. There's a foot to the neck. Ask yourselves, if those are actions of a determined killer, according to Mr. Davis, or if there's another explanation for those actions. She's fleeing to the back of the car to get some tactical advantage, or is she trying to get away? There's two ways to view this. Count 1, murder. As the judge read, caused the death of Donald Castleberry as an approximate result of committing an offense of violence that is a felony of the first or second degree, felonious assault, and there was a stipulation that it is. So, did he cause the death of Donald Castleberry? We know that, yes. As an approximate result of committing a felonious assault, of knowingly causing or attempting to cause physical harm with a deadly weapon. He fired that weapon. He caused the harm. Clearly, these elements have been met. Person acts knowingly, regardless of his purpose, when he's aware his conduct will probably cause a certain result to be of a certain nature. An officer knows when he fires a weapon that the probable result is that it's going to strike somebody and hurt them. We have to prove all these elements. This one, I submit, is an easy one. Voluntary manslaughter while under sudden passion and a sudden fit of rage, brought on by provocation, occasioned by Donald Castleberry, reasonably sufficient to incite him into using deadly force, knowingly caused her death. So you look at this one here, and you ask whether or not he was provoked. Whether he denies it or not isn't the issue. Whether you see evidence of provocation, of him getting mad, of him being incited into it, being in a sudden passion or sudden fit of rage. and this is unusual, and the judge told you, you can't find him guilty of both. You can only find him guilty of one of the two charges. And we've tried to make it a little bit easier for you with this charge. Has the state proven beyond a reasonable doubt the elements of murder? If not, not guilty. You're done. If yes, you must consider whether the defendant has proven justification by a preponderance of the evidence. If yes, you find him not guilty of both counts if justification is proven. If no, you consider whether the evidence establishes provocation by a preponderance of the evidence. If it does, you find the defendant guilty of count 2 and return no verdict on count 1. And if you find that it does not establish provocation, then you must find guilty of murder and no verdict on the voluntary manslaughter. The most objective evidence here is that video and audio. The objective evidence shows that the defendant's story doesn't match that. It shows he got mad. The objective evidence shows that he saw the knife initially. It shows he got cut in the front seat. The objective evidence shows he was on top of her in that car. She was still on her side. She was not on that dash. Look at the rearview mirror. Look at the evidence. See if anything looks disturbed. The objective evidence shows he was in her space. He was the one in control. He wasn't pinned. The objective evidence shows she fled to the back seat, that the door was open, that he had time to undo his seatbelt, open the door, go for the gun, step out. The objective evidence shows he was never cut again. It shows the knife was found on his seat. It shows she was shot in the back seat. Objective evidence shows she was saying, okay, okay, I'm sorry, I'm sorry. The objective evidence shows long, deliberate pauses between those shots while he yelled during the shots, fuck, goddamn. And then at the end, fucking nightmare. Even giving the defendant every benefit of the doubt and taking his word for the events, our expert, who fairly conceded many points, said he did not act as a reasonable officer. He was not justified. He did not take into account the circumstances changed. He fired 3 shots blindly. He didn't even assess. He made up his mind he was going to fire that gun well before he even turned to look at Donna. He shot until his gun wouldn't fire anymore. That is not justification.
Councilwoman Brooks? Off the record. ladies and gentlemen, but I'm not a good manager of time. So what we're going to do is typically we try and go through, we got the defense closing yet to go, then we have a rebuttal closing, and I never keep any of the court personnel or any of my jurors after 5. But we wouldn't be able to get through all of that prior to 5 o'clock. So what we're going to do is break for the day, and because the case is not completely submitted to you, do not discuss this case among yourselves. Do not permit anyone to discuss it with you or in your presence. It is your duty not to form or express an opinion on the case until it is finally submitted to you. And I'm going to have Courtney collect all of your jury instructions, and we'll give them back
You can actually just leave them on your chair.
Yeah, just leave them on your chair. And I won't forget, if you can be here by 8:45, we'll start at 9 o'clock, or try to start at 9 o'clock. And everyone have a good evening, all right?
All right. Just leave it on the chair and I'll grab it. Yep, leave it on the chair in here and I'll